many shrimp, I got iodine partners.
My bitch a choosy lover, never fuck without a rubber. Never in the sheets like it on top of the cover. Money on the dresser, drive a compressor. Top notch hoes, get the most, not the lesser. Trash like the buck for $40 in the club. Fucking up the game, bitch, it gets no love. She be cross country, giving all that she got. 1,000 a pop, I'm putting business off the lot. I smashed up the gray one, bought me a red. Every time we hit the parking lot, we turn head. Some hoes wanna choose, but them bitches too scary. Your bitch chose me, you ain't a pimp, you a fairy.
A pimp, not a simp. A pimp, not a simp. A pimp, not a simp. We eat so many shrimp, I got iodine partners.
Baby, you been rolling solo, time to get down with the team. The grass is greener on that other side, if you know what I mean. I show you shit you never seen, the 7 wonders of the world. And I can make you the 8th if you wanna be my girl. I say my girl, I don't mean my woman, that ain't my style. Need a real street stalker, walk a green mile. Be piling up the paper on the dining room table, cause you able to realize I'm the truth and not a fable. Baby, rockin' Russian sable, keep that chiller on the rack. What I look like with some $1,000 shit up on my back. I'm $1 million man, they need $1 billion bitch. Put my pimpin' in your life, watch your daddy get rich. Easy as ABC, simple as 1, 2, 3. Get down with UGK, Pimp CBU with B. Cause what's a hoe with no pimp, and what's a pimp with no hoe? Don't be a lame, you know the game and how it goes. We try to get toes.
A pimp, not a simp. A pimp, not a simp. A pimp, not a simp. We eat so many shrimp, I got iodine partners.
Welcome, everybody. Happy Wednesday. Thank you very much for watching, and I appreciate you guys coming in to take a look at part 3 of the Blandino saga. Tonight, we are going to take a look at the competency portion of this endeavor. So there might actually be a part 4 to bring us fully up to speed with Mr. Blandino's situation. And the timeline of events is going to take us between approximately September 2019 through April of 2020. So right now, and I'm going to show this to you guys real quick. So hello to everybody. By the way, I've sent out the Christmas cards to you guys. They're in the mail. And so hopefully some of them will make it to you guys before Christmas. So now what I want to do, there we go, is this was the very last video that we saw before we finished part 2. And the only reason I wanted to show this real briefly is to highlight what was said by the prosecution beforehand. And here.
Marlon, on behalf of the state. In addition to this, we have one other matter that we want to address today.
What would that be?
We do have a motion that we'd like to file on serving the defendant in open court with the motion. It's a motion to remand defendant for competency proceedings.
We just asked them
court,
to fix it.
and we're going to ask that this be set to when Judge Levitt is present to hear.
I think if I...
So right there. So right there is when the state filed the motion to remand for competency proceedings.
Unless I'm mistaken, I think the defendant has already categorized himself as a vexatious litigant. I mean, that came out of his mouth.
I object.
You object all you want.
All right. Well, I mean, we already saw this, so we can move forward to the next portion. We have a fair amount of videos to get through, so I don't want to waste y'all's time.
767, counsel, you're here for the record.
We are now in October 4th, 2019, and let's listen in.
On behalf of the state.
Tim Blandino appearing pro se for Tim Blandino with standby counsel Ben.
Yes, good morning, Your Honor. Ben Baden, part number 933. That has been appointed as
He's elbow counsel. I have some administrative and procedural matters before we even get to anything.
Well, hold on, this is status check counsel.
My understanding is that Mr. Blandino has not yet been evaluated, and so the court's going to need to continue this out for him to be evaluated. As a result, we're going to need to vacate the current trial date, let's say.
Mr. Blandino. Have you been evaluated?
By who? My friends and family evaluate me as perfectly sound and knowing quite a bit about the law.
That's not what she asked.
Okay, so you haven't been evaluated by a doctor yet?
I've been to this Holt clinic where they're a medical doctor, but not. Are you meaning psychologists or psychiatrists?
Counsel?
I just want to be specific for the record.
Yeah, so we would just need him to be evaluated by 2 psychiatrists or psychologists pursuant to the court's order to have him evaluated here in the competency court. As a result, it's going to necessitate us vacating that trial date.
Is there any objection to vacating the trial date and setting a new date?
I have some administrative and procedural matters. I don't want the court to just gloss
Drink.
over those. I have a right to
We're
make a
gonna
record.
get to those
Drink.
in a minute, okay? But first I want to deal with this issue. This is why it's on calendar today,
Yes,
so let's
I have
deal
an
with it.
objection to this entire competency proceedings. This is
Okay,
merely
so we're gonna-
vindictive on part of the DA's office.
All right, everybody take a deep breath. All right, now, do you have any objection to vacating the trial dates and continuing them?
If you want to continue to another date, you're not the normal judge, I understand, on this case anyway, so I don't have an objection to that continuance. I just have objection generally to the going through competency proceedings. I don't
Standby
waive the
counsel,
right.
do you have any objection to vacating the trial date and setting a new date?
Well, I do not. I think, obviously, it's been ordered, so, but, court's indulgence.
Oh, no, I understand that.
Thank you for the membership.
For the record, to be
Mikhail
known
Abdullah.
clearly, Judge, and I haven't waived my speedy trial right. I was willing to waive the time that the DA objected to. However, they were the ones that asked for the stay in
Hey,
the
Wazoo.
Michelle Levitt's court to go through these competency proceedings, which is merely vindictive on the DA's part. So therefore, I don't have any general objection to continuing it. I mean, I think that's fine. You're not, is it Linda Bell was supposed to be here on this case? I understand you're subbing in. So one of the administrative and procedural matters that I wanted to address was the fact if there's a written request pursuant to District Court Rule 18 that requires, or that allows you to sit in for Judge Bell, because this is a court rule that's required to be complied with. Do you have such a written request from the judge that he's sitting in on this matter?
Mr. Blandino, I was assigned to substitute in today for the chief judge at her specific request.
Was it a written request?
Thank you for the membership, Manda.
The rule requires a written request. I've got copies of it if you'd like to see,
All right,
of the rule.
so do you object to me presiding over this case today? Is that what I'm hearing?
Well, I have a general thing that I was not able to present. This court needs to take judicial notice. There's a vexatious litigant order against me. Now, that's on appeal. Only the chief judge or the chief judge's designee can allow me to file any written motions. That's why you haven't seen any opposition to the competency proceedings, except for, this is one of the administrative matters that I wanted to bring up. I sent, Your Honor, an email copy to the district attorney.
Thank you for the
both
9
Peterson,
months
Marlin,
membership,
and to
Akira.
Judge Bell and to Judge Levitt. And so I said that, hey, look, a number of different issues that I've got no other way to do this. It wasn't ex parte
Right on, Trevor.
communication. Apparently your JEA indicated that that is ex parte, but if I'm serving the other party with a copy, I don't see how it could possibly be. But even so, Rule 2.9, which I adequately copied and sent by way of email.
Thank you for the
shows
membership,
clearly that
Edward.
There is ex parte communication, either inadvertent or otherwise, as long as the opposition has an opportunity to respond to said communication. You're perfectly well within the Rule 2.9. Now, since I can't file any written motions without the chief judge designees, because Judge Bell actually has an unadjudicated motion to disqualify against her. But my
Howdy,
position
Archangel.
is, and always has been, that this case needs to be assigned to a judge outside of this district. I'm gonna have to call multiple judges in this case. I've been accused of impersonating.
So a lot of what Blandino's saying here is, I think this is what I believe Blandino's shtick is, or his basis for, you know, disqualifying everyone under the sun. His argument is that because he has been voluntarily investigating judicial corruption of the entire 8th district, no judge of the 8th district can be unbiased to him because he's been investigating them. That is my understanding of why he thinks that no judge can sit in the 8th district can sit on his case.
A public officer, so I'll have to call as witnesses, subpoena with evidence and testimony and written documentation, members of the Nevada Commission on Judicial Discipline. I've been accused of...
Also, the other problem that he has here, and he's going to repeat it a lot, but I'm going to just mention it here. He keeps on saying that he plans on bringing in several judges and prosecutors in as witnesses in his criminal case. That's not going to happen. The main reason being that their testimony isn't going to be a factor as to whether or not he committed the crime of extortion against this particular pro tem judge, Mr. Federico. The way I'm thinking it, to try and glean his logic, he thinks that if he brings these judges onto the witness stand and can prove corruption or prove that he's doing this investigation on them, therefore what he did or what he allegedly did with the pro tem judge was either justified or not extortion. I think that's what he's trying to glean from his logic there.
Extorting the temporary judge. And in that regard, it's absolutely imperative to show that I've been doing this for years, so I'm going to have to call Judges Herndon, Judges Baer, ex-Judge Maupin, ex-Justice Maupin now, all these different things to show that I have in good faith been investigating judges for corruption and for misconduct for many years now. And I didn't even realize that for many decades I've been brought to the point to which I've been brought here now. And that is having all this information, all this legal knowledge, and knowing procedures. I've been put to this position to make these claims. And so the DA wants to do a drive-by conviction of felony. And Kim's counsel, which is me, is not going to allow that. Kim has to represent his client, which is me, zealously and vigorously, and will do so to the best of his ability. I'm doing this full time. I'm doing basically nothing but eating, sleeping, and doing legal work.
Okay.
You know, aside from the normal chores that you have to do, make your bed and things, but that's all I'm doing. And so, if they want to do some kind of drive-by trial,
yeah, it's a
vindictively put me through these.
Referencing himself in the third person is a drinkable action.
I'm going to object to that, and I'm going to object generally to any district court judge hearing this. I've got a prima facie case. Manning versus State was just decided just recently. It's coming back down on vindictive prosecution. When a prima facie case is made for vindictive prosecution, there has to be an evidentiary hearing for that. Now, this latest scheme by the district attorney to put me through competency proceedings based on my filings before the Nevada Supreme Court.
Not really. I mean, if he's referring to legal work for himself, then that's not unlicensed practice of law. And that's how I took what he said there, is that he's referring to his own legal offense.
Clearly show additional vindictiveness based on my religious beliefs and my right to exercise my religious beliefs and my right to seek redress from an appellate court. They're saying, okay, Kim, we'll turn the screws to you just a little bit harder now and put you through competency proceedings. And maybe, just maybe, we can find some psychologist that's off his meds or something and will find you incompetent and relieve us of the necessary prosecution, and then they can lock you up in Lakes Crossing for some time. Well, Kim cannot allow that to happen, as good counsel that he is, if the defendant could speak for just a minute, as I just did. But I have a general objection to that. Because of the vindictiveness of prosecution, they really should recuse themselves. They know it's vindictive. I just got discovery yesterday after they, in open court, said on their honor they would have it in the Justice Court. Now all of this information, it appears, they had, as of May 30th, of this year, and now they're just delivering it. They violated the 5-day promise within the preliminary hearing. Now granted, they went to a grand jury indictment. That doesn't negate the vindictiveness of this, though. Huh? It's a home machine.
Counsel, any objection to me hearing this matter? State.
No, Your Honor.
All right, what I'm going to do is vacate the trial date, set it for status check and competency court. Thank you, Mr. Blandino.
What
November
day is
1st,
that?
10 a.m.
I'm sorry?
November 1st at 10 a.m.
November 1st, and then which court is that going to be?
Right here.
All right.
So in 10C, or is it going to be in Judge Bell's court?
You know, I don't know.
And Your Honor, we'll issue a written order on that. That's just want to confirm that all proceedings are being suspended pursuant to NRS 178.405.
Correct, counsel.
Thank you.
There was one other administrative matter, and this is important to get on the record. I had issued an objection to Mr. Ben Bateman being a standby counsel, and that was in Levitt's courtroom, because I hadn't interviewed him, didn't know if there was any conflict. I want to, for the record, say that I approve of Mr. Bateman as my standby counsel. I withdraw the objection that was entered.
Thank you, Dee, for joining in as a member.
The last time in Judge.
Noted. Thank you, Mr. Bateman. Have a wonderful day. Next.
Thanks, Judge.
Next.
Okay.
We can call page 1, please.
What's the matter of State of Nevada versus...
Real quick, Mike, if you're able to, you can join in on Discord, and we can set it up so we can both watch this together. So let me know there. Also, I forgot to mention this, just as a brief note, that Not a Brat's son, he has wanted me to let people know that Not a Brat has been in the hospital. She's not doing so well, and just he's asking me to request from you guys your thoughts and prayers for her, as she's doing I don't know what the situation is specifically. He just says she's not doing so well in the hospital. He just want to let you guys know to give her any of your thoughts and prayers for her.
Romello.
37, State of Nevada versus Kim Blandino, case number C341767.
Judge M&M and MD from the DA are here, so I think they're going to want to trail this. That would be Melanie Marland and Michael Dickerson. They're the assigned DAs.
I haven't followed you. I don't think it's
Yeah, Mr. O'Brien usually does all of these, Mr. Blandino. So,
oh, okay. I asked him earlier. He said that he wasn't doing that.
I don't know, sir. So,
Oh, by the way, now we are now in the what, the chat? This is now in November 1st, 2019. And so we're about a month later after October, where the trial had been vacated because Mr. Blandino had yet to speak to a doctor or psychiatrist regarding his competency.
I want to state that I'm in custody under punitive house arrest.
all right. So, Mr. Blandino, my job here is just handling the competency part.
But
So,
we have some administrative matters before we even get to that. By the way, let me enter my appearance. I'm Kim Blandino, appearing pro se for Kim Blandino. This is Ben Bateman. He's the assigned standby counsel, otherwise known as elbow counsel.
okay.
He wants to give us
Good
the
morning. So,
bar number. But you have there's an unadjudicated motion to disqualify you for bias. Now, I realize it's in another case,
right,
but it's
Mr.
still
Blandino.
outstanding. Therefore, you cannot
Miss-
sit.
I'm not making any decision on your case today.
And so my understanding at this point is that Blandino did in fact file a motion to disqualify Judge Bell, who we're looking at right now. And because of that, because it was properly filed, Judge Bell is making it clear and is making it noted that she's not ruling on anything today. She said it herself that she would have had another judge, come into this hearing if she was able to. She's explicitly saying she's not making a ruling. She's simply encouraging Mr. Blandino to comply and speak to a doctor to set up an appointment, or else he may end up being remanded for competency.
Otherwise would have had a different
Because again, right now he's currently out on house arrest.
judge in here. I was just going to encourage you to talk to the doctors, because I anticipate if you do not cooperate with the doctors that a judge hearing this would put you in custody so the doctors can come and talk to you, or they would have to send you up to the forensic hospital. But since today I was just going to issue that warning, I was just going to sit and not have somebody else sit. Well, we don't need to make any records, sir. The only thing on today is that we don't have the evaluations yet, so I was just going to
Well, I haven't
really...
been given an order that I'm supposed to be evaluated, and there's no written order.
Sir, I'm just telling you, if you do not participate in the evaluations, the likely result of that is that you will be remanded into custody, and I would hate to see that happen.
Excuse me, Judge, let me make a record as to that issue. You're talking about cooperation. I have the right and rights not to waive any of my rights. And this is a court of record.
You do, sir.
And therefore, if I am given a written order to cooperate with those doctors or to do this evaluation, I will obey that written order. But verbal pronouncements from the bench, as in Russ Clark County School District clearly states, without a written order, the judge could change their mind at any time. Further, I have not been allowed to file a motion to oppose the referral to competency proceedings. As you know, there's a vexatious litigant order against me. It's currently on appeal. The opening brief and petition was filed yesterday with the Nevada Supreme Court. Therefore, I am left without any defenses in terms of writing. The only way I have to communicate with the court is by way of oral communications when I'm in the court.
I understand, sir. I understand.
So, if you judges do not want to comply with the rules, the law that you require me to in both Loretta canvases, that is, that I have to follow the rules just the same as another lawyer would, then you judges, you lawyers have to follow the rules as well. So give me a written order that has me go to those doctors, and then maybe I can appeal it. But without a written order, I can't even appeal it or ask for extraordinary relief before the Supreme Court or the Court of Appeals. So therefore, I object to these proceedings, and I consider what you're saying here as a threat that if you, Mr. Blandino, don't waive your right to have that written order, we're going to incarcerate you. That's the way I take this, and I would have to take this.
I am just explaining what the procedure is, so I certainly don't mean that as any kind of threat. It's actually...
Well, if you want to talk about procedure, Administrative Order 077 requires that Department 5 do the competency.
We're going to pass this 30 days.
December 6th at 10 a.m.
Do I get a written order or not?
Sir?
Be back at December 6th.
What if he already knows and has already called her out, saying that she has a motion to disqualify already on file and unadjudicated? Why is he also demanding a written order when she can't make a written order?
You have a new court date in 30 days.
Thank you. Oh, by the way, thank you, DK, for joining as a member. Thank you, Auditor Investigation, for the $5 super chat. My take is that he believes the court screwed him over on the kidnapping conviction, and that this is all nothing more than payback, in my humble opinion. I mean, I can buy that. And thank you, Sonia Garlic, for the $12 New Zealand.
Thank you.
I object to these proceedings for multiple grounds, and I object to not being able to make a complete record. I still have things to say.
They always do. That's fine. They can just go. Thank you. Appreciate it. We're fine.
Is my objection noted for the record?
Your objection is noted for the record,
And it's
sir.
a continuing objection.
Yes, sir. All right. probably should have called out one out of order. All right.
George R. Passarelli Jr. Okay. I'm going to take care of it. We'll call you.
14.
Why can't she make a written order? Because at that time, Blandino had filed a motion to disqualify. So, and according to the Nevada rules, once it's been properly filed, the judge cannot actually act, which Blandino will eventually use to his advantage later on. So she can't make a written order. She can't make any written or verbal order, for that matter. All she did at that hearing was say, I'm here just to encourage you to go through and have the appointments with the relevant doctors. That's all she did. That's all she could do at that point. Also, Wazoo, thank you for upgrading from Indigenous to Sovereign as a membership. Thank you very much. Archangel, I mean, yes and no. I'm not, again, I'm not a Nevada lawyer, so I'm not familiar on Nevada's rules. But it seems like Nevada, you are, judges are permitted to put verbal orders on the record that may be enforceable. But I do believe like certain things like final judgments, for example, have to be written, right? I'm not familiar with the rules, but verbal orders can be, have force and effect, but I'm not 100% sure where that allowance ends, for example.
This is a matter.
Now, okay, by the way, now we're in December 2019, and again, we are not, Mr. Blandino has not held a competency hearing.
Of State of Nevada versus Kim Dennis Blandino, C3417671. Mr. Blandino is president. Counsel, your appearances for the record.
Melanie Marlon for the state, Your Honor, and Michael Dickerson.
But this is going to be a bit of a long one, so sit tight, but it'll go by.
If a court may, a preliminary matter, I would please ask the court not to use the middle name Janice. I repeatedly said that.
Oh, I apologize.
If you want to use the second initial as D, I'm fine with that, but Kim D. Blandino, if you want.
Mr. Blandino, how about just Mr.
There's not a lot of us in this country.
How about
Kim
Mr. Blandino? Does that work?
Mr. Blandino's fine.
All right, counsel, what's the update on this case?
Before we get anywhere, though, I have a motion to disqualify you, Judge Levitt, and Judge Bell. I want to file it in open court, and I have service copies for, even though this is
the motion to disqualify.
only courtesy service for the district attorney.
Oh, thank you for
Can I approach to have this?
No, not quite yet. Hold
Because
on.
you cannot move forward once this thing is actually filed and presented.
See, this is, again, because Blandino knows that, he uses that to his advantage a lot throughout these proceedings. And from here up until what we saw in the beginning of this month, that he constantly files these motions to disqualify. We're going to see more of that.
So there's really no point in you moving forward because there's not only bias and prejudice under 123L 1.235 as well as the Code of Judicial Conduct, Rule 211, but there's the intolerable unconstitutional risk of bias pursuant to Echeverria v. Filson, which is a Ninth Circuit Court case regarding the intolerable risk of bias. And so therefore, I ask that if this will render anything going forward moot, I tried to get a hold of the district attorney as an administrative matter. This order that was now in writing that I demanded before Judge Bell, who was improperly sitting last time because there's an unadjudicated motion to disqualify her. She admitted on the record, I have the transcript here, she admitted she was only there to sit there to advise me to cooperate with a psychologist, yet there was no written order demanding I do anything. Well, finally, you apparently signed that order. Is that your signature on it? Because I only have here.
So, Mr. Blandino, if that's actually you in the chat, Marquis did actually sign a written order, but of course you make challenges to it.
Say, that says you signed that order.
Counsel, I signed an order in this case. I remember signing it.
I can't tell from the signature
Well, most
that you.
people can't tell from my signature. It's
True.
a little messy, Mr. Blake.
But
I
anyway,
apologize.
this order is totally insufficient because it doesn't comply with the statute. The
Okay.
statute requires, and the DA has taken the position that they won't even speak to me. NRS 178.415 says the court shall appoint 2 psychiatrists, 2 psychologists, or 1 psychiatrist and 1 psychologist. And the tail end of this order says that it is hereby ordered the defendant shall be examined by psychiatrist and or psychologist. Well, that.
Amy, hold that thought, because they're gonna actually have a discussion on whether or not Kim is allowed to file this particular motion to disqualify. Hold that thought. They're going to answer that for you. Thank you very much for the $5.
Would include possibly 1 person or possibly 2 persons. And you know from the statute that it has to be 2 separate persons.
Right, okay.
And so this order needs to be vacated. It's just in and of itself. Plus the thing was sloppily done. I don't know what a psychiatrist is or a psychologist. It has order for defendant to be examined by psychiatrist and or psychologist. You want to see a copy of that? Now, it's a typo, I granted you, but for all I know, psychologists have been created in this world.
Maybe, I don't know. So let's get back to the motion to disqualify.
Here it is. I'd like to file that in open
Well,
court.
hold on a second. Counsel, has that been filed yet? Is that part of the record?
That's not.
It hasn't been filed yet? Okay. So I'm not going to allow you to file it in open court today. I will allow you to file it at the clerk's office on the 3rd floor or at home on your computer.
I would be violation. I have to point out that if I go down there and I'm not in court, I'll be in technical violation of the order. I'm only supposed to be here for court appearances. So unless you give me specific permission to go down there, I'll be happy to do it.
Well, then I'm not going to give you, you've already been deemed vexatious. Is that correct, counsel?
No, but I've been given written permission by Judge Levitt to file this particular motion.
Judge Levitt gave you written permission to file that?
Right.
Let me see it.
Now, there it is. Now, Blandino is claiming that the motion to disqualify that he has in his hand, he was permitted by the chief judge, Judge Levitt, to submit that. And what he is saying that he is allowed, the title of his motion to disqualify is Levitt, Bell, 1 or 2 other named judges, and the entire 8th District Court. That's Blandino's contention.
There's an order. It's on the motion to disqualify as an exhibit.
Counsel, have you seen the order from Judge Levitt allowing him permission to file the motion?
They prepared it. They better have seen it.
That's correct, Your Honor.
Hold on a second. Before I rule on anything in this case, I need to know if he has permission from Judge Levitt to file a motion to disqualify against moi.
Not against
Not against
Your
you,
Honor.
Your Honor.
Yeah, the judge here, Judge Marquis, is saying, does this order that Blandino's trying to present, does it permit the motion to disqualify me? Not just these other judges, but me specifically.
However, Judge Levitt did allow him to file a motion to disqualify prior to initial arraignment in District Court 12. There is an order.
Against Judge Levitt?
Against
That's
Judge
correct.
Levitt, that is correct.
Mr. Bateman, do you think that's a correct statement of the record?
As I and I believe that was granted before I was appointed on this case.
Well, see, the motion is entitled, motion to disqualify judges Michelle Levitt, Bell, Marquis, and all the judges of the 8th Judicial District Court pursuant to NRS 1.230, 1.235. The Nevada Supreme Court, when I presented them with that order to disqualify, and my position was, well, you're impersonating the chief judge if you do that.
Well, I don't want to impersonate the chief judge.
No, but then
Mr. Bateman.
in a footnote order, Chief Judge Gibbons said that you've got your relief because the trial court judge allowed you to file it, therefore they have the authority. Now, I think they're misreading
Mr. Bateman, is the order from Judge Levitt, does it give him authority to file a motion to disqualify Judge Levitt? Or does it allow him the ability to file a motion to disqualify the entire 8th Judicial District Court?
I would need to look at the order specifically, Judge.
I'm looking at the order.
Oh, you do have it now.
Hold on. Order granting defendant leave to file a motion to disqualify Department 12.
So, Blandino is incorrect. The allowance was to disqualify the entire Department 12 which is within the 8th district, not the entirety of the 8th district.
So that's not the entire district court. So today, I'm not going to allow you the ability to file that motion. It was granted.
Mike, come on, man, you got to learn the Discord and get in on this.
You have the ability to file a motion to disqualify that department and no others, all right?
Well, then I would ask for, if you're not going to allow that, then I demand to be allowed to file a motion to disqualify you, Judge Bell, and Judge Levitt, as well as the other 8th Judicial District. This matter has to, because of the risk of bias and everything, and really, if you were going to be absolutely above board and totally honorable, in the highest sense of the word honorable, I would not have to file a motion to disqualify. There's plenty of facts in the record. All the Justice Court transcripts have been filed into this case. You would see that there is an intolerable risk of bias, and I shouldn't even have to file a motion to disqualify. You should, sua sponte, which you have the authority to do, assign this case to a judge from another district. Because Judge Levitt admitted in open court that when I told her I'd have to call her as a witness, which I will if it goes to trial, I'd have to call Judge Herndon, Judge Baer, I'd have to have some other witnesses come, because there's been correspondence between us to the very underlying issue of impersonating a public officer. I have in fact made overtures to them to apologize or otherwise correct their behavior without having gone to the Nevada Commission on the Judicial Discipline. They had full authority, knowledge that I was investigating judicial corruption and misconduct on the 8th Judicial District court judges, and for that reason.
So here's where he repeats himself and saying he's on what he would describe as like a crusade of justice against the 8th district, and because I've been investigating all these judges, none of these 8th district judges can possibly be unbiased against me.
There's too much risk of bias, so you really should recuse yourself and assign this to a district court judge. It would save a lot of paperwork, and the district attorney, if we could have a little conference, I think it would be in their best interest. The other matter is...
So hold on, let's deal with that issue. Counsel, do you have any objections to his oral motion for me to sua sponte, recuse myself today, and appoint a new district court judge from another division?
Absolutely, Your Honor, there's absolutely no basis for that whatsoever.
Do you have any concerns about me sitting on this case today, Steve?
We have zero concern.
Mr. Bateman, do you want to be heard on this issue?
He's my standby counsel. He has to vigorously and zealously defend my position.
Thank you, Mr. Bateman.
I don't have any representations, Your Honor.
Thank you, Mr. Bateman. Today I'm going to deny your oral request for me to sua sponte recuse myself and to appoint another district court judge from another division to rule in this case. So what was your next issue?
Well, so you're going to deny me the right to file this motion to disqualify you in open court?
That was not your request that I just ruled on.
No, I understand that.
I'm not going to allow you to file that motion in open court today because the order you are referring to does not say what you told me it said. You told me in court today that Judge Levitt allowed you the authority to file that motion. Judge Levitt didn't allow you that
Yes, she
authority.
did. To file against her. You're saying that in
but not
part.
against me.
But not against her.
In part.
So, that motion is for the entire 8th Judicial Court. Okay?
Well, no,
For every
it
judge.
specifically lists Levitt, Bell, and Marquis, and then all.
Yeah, so I'm not going to allow you, because you have already been deemed vexatious, you don't have an order allowing you to file that, I'm not going to allow you to file it today. If you want to ask Judge Levitt if you can file that motion, that you can do that. Counsel, what's the status of this case today?
Today, this is the second time we've been here where the defendant has failed to follow through with the court-ordered psychiatric evaluation. In addition to that, the state is seeking to have the defendant remanded on that basis to start facilitating those evaluations, but also on the basis that It's come to our attention as of yesterday. The defendant has been making contact with and attempting to make contact with Ms. Talia Williams, who was sitting as the Justice of the Peace pro
Operative word
tem
there was sitting, she's no longer sitting.
in
Oh, so a bit of backstory here, because again, I've been following this shit way too bad, so I can actually understand a little bit of the backstory. Judge Talia Williams, well, Blandino has already been filing these motions to disqualify for months now during his criminal case. So as part of that, Judge Talia Williams was one of the judges brought in to rule on the motions to disqualify. And I believe at this point, she has. Now, what the state's, the prosecutor's going to allege is that Blandino has now been targeting Judge Williams with letters, phone calls, etc. So let's listen in.
Just to make with Talia Williams?
Yes.
And she was sitting as a pro tem?
Yes, that's correct.
Was.
In this case, in the Justice Court,
in the Justice Court,
prior to the indictment, specifically, the defendant in September sent her a letter with very similar representations to what he was making to Mr. Federico in this case, saying, hey, you either need to apologize to me and resign as a pro tem, or else I'm filing a complaint against
That's
you.
not true.
Then in November 2019, just a couple of weeks ago,
Well, we were last here on November 1st, so since that November 1st date.
Object to the word we, you were not here, Judge Bell was sitting there.
I'm sorry, I meant that we were in court, not me, but another judge in the party.
Thank you for that correction on the record.
I'm sorry.
Appreciate it.
on November 25th, he went up to her office. He
Went to
dropped-
her office?
Yes, her
And
private
she's in
office.
private practice, is that right?
That's right.
She's not an employee of the Justice Court, so
so just like the pro tem Judge Federico, Blandino went to Williams's private office to deliver letters and also allegedly called the office himself.
she doesn't have.
No, she's a temporary judge.
She doesn't have the security at her offices that we enjoy in the district court and the justice court. She doesn't have a
I had
marshal in
permission
her
from the
office.
house arrest officer to go there to deliver those papers. Specific permission. They tried to have me
Hold on,
arrested yesterday,
Mr.
and
Blandino,
this is a stand-up
Mr.
now.
Blandino, I'm gonna let you speak in a minute and
Okay.
respond, but I need to hear what the district attorney's trying to tell me.
It's our understanding that he did tell house arrest that he was going to go somewhere.
No, I
When he
asked house arrest.
Mr.
What?
Blandino,
I didn't tell him. I asked
hold
him.
on, Mr. Blandino, please give him an opportunity to talk, and then I'm gonna give you.
I don't like him lying and miscandering. The candor rules under the judicial, or the lawyer, he has to have candor before a tribunal, and when he misrepresents by saying, I told my house arrest, it's clearly wrong, he knows it's a lie, I asked him for permission, and he gave it to me.
Okay.
There's a difference between telling and asking.
Mr. Blandino, I'm
So-
gonna give you an opportunity to speak in just a minute, but I need to hear from him uninterrupted. I'm gonna ask him not to interrupt you.
Kit, thank you for $2, and Akira808, thank you for the $4.99 to answer both your questions. Technically, yes. I mean, if a judge is having a not so good day, if a judge has a short fuse, then yeah, if Kim Blandino keeps up with the interruptions, he can be held in contempt.
Okay?
Thank
Go
you.
ahead, Counsel.
What he told house arrest was that he was going to go to a lawyer's office to drop off some paperwork. He did not tell them that he was going to go over to the Judge Pro Tem's office, who was sitting.
Thank you, Joshua Lee, for the $10.
Her paperwork that is substantially similar to the intimidating paperwork that he's given to the victim in this case. Miss Williams is intimidated by the defendant. She is in fear of him. He went to that office. He dropped off a similar letter that has the same type of representations. He also dropped off the first letter again that was sent in September because she had marked it return to sender. Later that day, he then called the office trying to speak with her.
He
Ultimately-
dropped it off, and then he called in the same day?
Yes, that's correct, Your Honor. Yesterday, detectives went, they collected those documents, they got voluntary statements from her receptionist who actually made contact with the defendant there as he was dropping off the paperwork. We provided the court with all that. That is in a motion that we now are moving to file to remand the defendant. So that's on two bases. First, that he's failing to comply with the court's order to have his psychiatric evaluations so that we can just get through these competency proceedings and determine if we could proceed to trial in this case. And secondly, because he continues to violate the court's orders of being on good behavior while he's out on house arrest and out on bond in this case. Specifically in June of 2019, Ms. Williams, while sitting as a judge pro tem, told him specifically on the record, do not contact me. Do not contact me in my private life.
I've got the transcripts, that's not true.
And we've also provided the court docket as part of that motion as Exhibit 1 that you'll see from that June, I believe it's June 28, 2019, that she put in there what she told him. Do not contact me. Do not contact me in my private life. Don't come around. There can't be any ex parte communication whatsoever. And that is something.
She's concerned for her safety, counsel?
She is concerned for her safety.
Okay, anything else you want? So your request today is to remand him today
That's correct.
for failure to comply with the court's orders about being evaluated and making appointments with those doctors and scheduling with those doctors. You're just failing to participate in that process, is that right?
That's correct, Your Honor.
And also for reaching out and going to Judge Pro Tem's private office where there's no security handling.
Which I have permission for.
A letter.
Specific permission.
That the district attorney's office feels is threatening, that she feels.
Was not a letter, it was service of process.
That she feels is threatening?
That's right, Your Honor. And I think that it's rightfully felt by Ms. Williams to be threatening, since reading that letter, it seems to contain veiled threats throughout the letter, similar to everything the defendant has given to the victim here in this case.
So what the prosecutor is essentially saying is that Blandino has sent a letter similar to what he's currently being charged with. Part of what his charges are is extortion and impersonating a public officer by sending a letter to the pro tem judge Federico that if you don't clean up your act. And I think in the event portion of Our Nevada Judges, they mentioned that he also requested money sent to the law library or something like that. You'll have to check out that video. We'll check that out in part 4. And if you don't do that, then I'll file a complaint with the Nevada Commission on Judicial Ethics or whatever their ethics commission is called. Apparently, the prosecutor's alleging that Blandino sent a similar letter to the pro tem Judge Williams twice. One of the letters she returned to sender, and a second one Blandino sent again, but this time he slapped on service of process on it. Additionally, he also apparently called her office that same day, hoping to talk to the judge.
Right. And the victim in this case was a judge sitting pro tem in justice.
I'm sorry, Judge. Alleged victim. I'm presumed innocent.
And I accept your correction, Mr. Blandino.
This shows the bias and prejudice on your part. You're acting as though you're a sub-prosecutor to the prosecutor's office. This court should be well aware that I'm only alleged, and you're taking it as though it's a fact in evidence. This basis alone, you should recuse yourself right now immediately.
Well, I don't think anyone ever accused me of being a sub-prosecutor. But so.
Well, why wasn't the word alleged used?
Well, I misspoke.
Can I have an apology for that?
I think I already apologized, but I do apologize for misspeaking, Mr. Blandino. Mr. Bateman, would you like to be heard on this issue before I hear from Mr. Blandino?
Judge, Mr. Blandino's been he's had his Feretta canvas. I don't have any representations to make. He's made it clear what he wants my role to be here as a standby counsel. I'll respect that, Judge.
All right. Mr. Blandino, go ahead.
I can point out 3 clear lies that were told by the district attorney. And you seem to be inclined to listen to him and give him credibility and me 0. You're showing your prejudice right now. The inflection of your voice, the demeanor. Oh, and she felt threatened. I've had 2 separate...
The tone policing on this guy, come on.
TPOs filed against me, attempted to be filed against me by Federico, the complaining witness in this case, and by Judge Nordstrom. Both of those have been denied. They were denied because they were frivolous. And if I had the time, I would already have filed abuse of process action against Federico and against Nordstrom.
Now, see, now, if you listen to this guy, anytime some sort of affront is labeled against him, he wants to lay down the hammer in retaliation. I mean, if you even fart in his general direction, he's going to file at least 3 federal lawsuits against you. That seems to be the kind of guy that Mr. Blandino is.
And clearly, there's going to be one coming against Talia Williams here. The operative thing, it was not a letter, it was service of process, and it was titled as such. I'm entitled to try and resolve any issues of civil matters prior to, and even demanded by the rules, to try and resolve those before having to file a suit or other civil action. Now, it's an open question as to whether a complaint filed with the Commission on Judicial Discipline is a civil action or not. It certainly isn't criminal. So, in the court rules of civil, in all the court rules everywhere in this country.
So now he's trying to contend that his do I want to say threat? I mean, his condition that if you don't do X, Y, and Z, then I will file a complaint to judicial ethics is, I guess, an equivalent of a cease and desist letter, right? That's what he's sounding like, because he's now trying to link a complaint filing with the judicial ethics to a civil suit, which is not. But he's trying to make the case here that, oh, it's kind of like a civil suit, and so therefore what I did was okay.
It always talks about two.
Bear in mind, he's arguing his case now, and we're simply trying to figure out whether this guy's going to attend a competency hearing. But he's arguing the merits of his case. Bear that in mind.
Two separate actions. You've got criminal and you've got civil. The TPO process is civil, however, it incorporates into it possible violations of criminal law to support the temporary protection order. Those were denied. Talia Williams did not get a letter, she got service of process. I did, in fact, deliver it to my house arrest officer gave me specific permission. And I didn't tell him I was going to go there. If my house arrest officer had said, Kim, no, I don't think you should go down there, I did fully inform him that she was, prior to this, the temporary judge in the Justice Court case. I told him he was fully informed. I didn't tell. This is lack of candor. I intend to file. You should reprimand him right now because that's a lack of candor. And if he could admit the truth that I didn't tell. I asked. It wasn't a letter. It was service of process. There were acts of kindness in there. Part of this thing about getting her that information was to pay my hospital bill, or not my hospital bill, but medical bills. I happen to be getting treatment whereby you have to do 3 acts of kindness within a month to pay for your bill. And if you don't have a letter telling what you did to the doctor, you no longer get any services. It's Hope Clinics. And so therefore, I had information that was beneficial to Judge Williams. She has $25 at the state treasurer that needs to be picked up by her. And by her...
So he's claiming that, I guess, for his treatment in hospital, he has to do 3 acts of kindness. And apparently one of his acts of kindness is to send this letter to Williams, letting her know that she has $25 owed to her by the Nevada State Treasury.
Being a temporary judge and leaving that money outstanding, she's creating a greater burden for the state of Nevada by having the treasurer, because they couldn't locate her address to give her the money, on their books. I've done the same with Judge Linda Bell. She has money down there. Judge Delaney has money, almost $1,000 Judge Delaney has. I sent her a letter regarding that issue, and Judge Bell. Furthermore, the issue of security is there. When you judges and court personnel that want to keep your addresses secret from the public, and you take it off the assessor's page, which
Well, God, I wonder why they have to keep their addresses secret.
Fully entitled to do under law. You leave a backdoor security risk if they have money at the state treasurer, because it has Judge Delaney's address on there.
The fact that you're talking about how you know the home addresses for all these judges is not really helping your case right now.
Which she has specifically excluded from the state treasurer's, the assessor's office, her address. It shows a phony address downtown here. And so they gave backdoor. Now, Delaney is, interestingly enough, she was burglarized.
Why do you know that? Why do you know that? Why do you need to know that? Again, yeah, it may be a matter of public record that Judge Delaney has been robbed, but bringing it up in this context does not look good to you at all.
For all we know, Judge Delaney was burglarized because they found out this lady's a judge, and they had her address by looking at public records on the state of Nevada Treasurer's office. I told Judge Bell in her chief judge capacity that this is a backdoor security issue almost a year ago. That these judges need to keep up on this and make sure you don't have any outstanding money. Now I know that this is a result of laziness on parts of people like Nevada Power, and rather than just send out the money, if they don't have the address right in front of them, they say, well, let's just give it to the state treasurer. Because these are not addresses that they don't already have. So the legislature may at some time need to follow that. The fact that they are trying to go through the back door and create some kind of temporary protective order by means of throwing me in jail, and they haven't filed this motion to remand. If I can yield for just a question, to use the legislative type rules of order. Did you file this motion to remand yet, Mr. District Attorney? Has this been filed?
Your Honor, I'll be speaking to the court today, not to Mr. Blandino.
Well, I don't have a file stamped copy. I have an unfiled stamped copy. So I'm presuming, based on that, this thing has not been filed. So if you're going to allow them to file something in open court and not me, which they did before Judge Bixler, didn't even let me respond to it, there is so much misconduct, corruption, and just flat-out incompetence with the entire 8th Judicial District system. That's what I've been investigating. Now, the district attorney is going to look awful embarrassed when these things come to light, and I think this is vindictive prosecution. What he's certainly saying here, certainly today, is not only vindictive, but he's made 3 separate lies. Wasn't a letter, it was service of process, which I'm entitled to serve. I don't have...
We're going to find out whether that's true here in a bit. Real quick, $5. Thank you very much, Reverend Jason Reed. This guy's a conspicuous combination of vinegar and water. And thank you very much, Sean, for another $5. Pathetic.
Oodles of money in which I can pay for service of process. If that house arrest officer had said, Kim, he was fully aware Talia Williams was a temporary judge down in the Justice Court. If he had said, Kim, I don't want you to go there, I wouldn't have gone there. I got the mail back refused on the envelope. She didn't see it the first time because it was came to me from the post office.
Mandy, thank you for joining as a member.
And therefore, I had to get that information to Talia. She knows there's no threat. This is just a straw man that they're putting up. They're concerned for their safety. It's hogwash. The same events that
listen to this. I want y'all to pay attention here.
Happened with Federico and Nordstrom, where I tried to contact them. The TPO judge, Judge Kern in one instance, and Judge Jansen in the other instance, said there's not anything here to file a temporary protective order against.
Bullshit. Bullshit. You want to know why I'm calling bullshit? It's because you guys were here with me in part 2, where we saw both hearings with Judge Jansen about Federico's TPO request. And at no point did Judge Jansen ever say that, oh, there's nothing here to order a TPO. What happened is that Judge Jansen gave Blandino a condition that if he did not contact Federico for 30 days, he would not order the TPO. Blandino kept his word apparently, and therefore he didn't order the TPO. At no point did Judge Jansen ever say that the request for TPO was frivolous or that there was nothing there to issue the TPO. Now, the second issue, the TPO request that we didn't see, the judge did say that there wasn't enough continuous harassing contact from Blandino to warrant the TPO. I'll give him that. But he outright lied in court when he said that, when he made the claim that Judge Jansen thought asserted that the TPOs were frivolous or that there was nothing there to warrant a TPO.
And for you to feign this concern, and I use that word feign. Oh, she was concerned for her safety. I believe in God and His Son, Jesus. And I always follow the rule, the golden rules. Love your Creator with all your might, with all your strength, and love your neighbor as yourself. If I thought there was anything wrong or untoward, I wouldn't have done it. And I furthered that by asking my house arrest specifically for permission. So if they want to do this is just nuts. That case was dismissed in the Justice Court. And they told me that there was no continuation from the Justice Court to the District Court. All the case law shows that. As a matter of fact, initially, if the court will look at this record, you'll see that a warrant was issued, even though I was $50,000 bail and the house arrest from Justice Court.
Mike, is that you? Are you here? I think you just joined the voice chat.
Yeah, can you hear me?
Yep, there you go. I can hear you.
I'm on my phone. I'm watching you on my computer, but I'm on my phone. What?
Oh, damn. I don't know if we can watch together then, but we can watch it, hang out at least. The only issue is that you'd be watching via the stream and there'd be a delay.
All right, am I live now?
You are. Everybody can hear you.
Okay, but I can't watch.
Yeah.
That's the problem, so I don't know what's going on.
Oh.
But hi, everybody. Sorry. Here's all I'm going to do. I'm just going to say this is all my fault. I don't know Discord. I'll figure it out someday.
Someday. All right. Well, we'll figure it out at least in time for part 4, at the very least.
Sounds good.
All right. No worries, man.
And then when it got dismissed there, the warrant pops up here. Now, thankfully, my house arrest officer, who I have to commend, is a member of LVMPD. He should be wearing sergeant stripes and lieutenant bars because he's an upright, upstanding member of that force, which I can't say about all of them. But when I asked him, I said, hey, look, there's a warrant out. He called Pam Rocha, who's the JEA, for Judge Levitt and said, hey, he's got $50,000 bills. His warrant a mistake? Judge Levitt then proceeded to quash the warrant. Pam Rocha, her JEA, got to Judge Levitt and quashed that warrant. Furthermore, I asked Webb, I said, well, did you get it in writing? And so I said, no. I said, so I called Pam Rocha, and I said, Pam, would you do me a favor and at least issue a minute order on it? The minute order that's in the record, they have very well attached to.
At this point, I'm completely lost as to where he's on about now.
This motion shows that that minute order giving me that relief was in fact put as part of the record. That the warrant was quashed, and then I'm on this punitive house arrest.
Okay, so the request was to have you remanded for 2 reasons. The failure to comply and participate was scheduling an appointment with Dr. Catherine.
That order wasn't filed until yesterday.
Okay.
How could I comply with it? And it's defective, as I pointed out. It doesn't even comply with the statute. This is an illegal order, or it at least needs clarification. Now, I know you can clarify your clerical errors at any time. Denise's, the Denise over the specialty court, spelled D-E-N-E-S-E, and then Denise, who's in court often. I don't know if she's here today, the D-E-N-I-S-E, Baker, and the other Denise. And I said, look, Where is my order that says I have to do this thing? They sent me over an evaluation list, which was an order by the psychologist.
Thank you very much, John F. for the $5 and Reverend Jason Reed for the other $5 super chats. I have it on good authority that Jesus does not believe in Kim Blandino.
This is certified by the division.
Have you gone to one?
I called them.
Oh, now he's talking about whether or not he's required to go to the psychiatrist as deemed by the court. And he's saying that I should be allowed to go to any certified psychologist or psychiatrist in the state of Nevada. And the judge just asked him, well, did you go to one?
Them up. It says I have to do this thing. They sent me over an evaluation list, which was an order by the psychologist that they had picked out to cooperate in this process. And he said, wait a minute. The statute says that I can go to any certified psychologist or psychiatrist that's certified by the division.
Have you gone to one?
I called them up.
Okay, did you make an appointment and go see them?
That's not relevant to this.
I always laugh at that fucking long pause right there. Well, did you set up an appointment? That is not relevant to this hearing, Judge. How dare you?
Here. I got a list. I got a list of certified. The certification is only good of all the certified people in Northern Nevada and Southern Nevada, which under statute I could use anyone from Northern or Southern Nevada and be in compliance with the statute. But Denise proceeded to tell me that they only sent the various records to two people that they picked out. Now, to me, there's an issue possible to the Nevada Supreme Court as to whether they are doing a judicial function by them choosing who would more convenient. They said, well, they're more convenient because they're in the same building and they have the same telephone number. I said, well, just because something's convenient doesn't mean it's good. I can pay $5 for a gallon of milk at 7-Eleven, but maybe I want to go pay $2.50 at Smart and Final right around the corner. So convenient doesn't necessarily mean good. I did my due diligence. I checked on that. I demanded Judge Bell, who was in this hearing, I don't know if you looked at those prior proceedings, but she admitted she had no business sitting on the bench. She was only there to advise me to cooperate. And I said, look, because she was advising me that if I didn't cooperate, I could be thrown in jail. And I said, I don't have a written order. There's no written order demanding that I do anything. And I'm entitled, I do not have to waive my right to a written order in order to be ordered to do something verbally. Russ versus Clark County School District is very clear. A written oral pronouncement from the bench or even a minute order is not final for any purposes whatsoever. Because the judge can change their mind in between the minute order or the oral pronouncement and a signed and filed order.
Well, it's a good thing that, we're still in preliminary proceedings and we're not really in a final order situation. We're only in a competency hearing. So I have to look up that case that he keeps on bringing up myself, but I don't think he's appropriately relying on it.
And in fact, this order is crazy. I know you are a family court judge, and you know that when you order these evaluations for family court proceedings, you specifically assign a certain psychologist.
Well, just before, you were bitching about how you should be allowed to go to any certified psychologist or psychiatrist in the state of Nevada. So now you're mad that they didn't do that? That they didn't specify the psychologist?
Judge Lenkite or Judge Paglini or Mortallero or Harder, whoever happens to be certified to do that forensic work. This order doesn't state any particular people, and these people are taking the particular people, and they have certain files. I said, well, I need to see those files. It seems to me we have a potential and serious due process issue. The court, in looking at all these competency proceeding issues, and I looked at them all throughout the country, not only on the state level, but on the federal levels. And there's a fact of raising doubt about a person's competency in the state court. The federal courts, uniquely enough, put it in the positive thing, and they don't say whether there's doubt, whether there's reason to look at something. But what they say over and over again, before somebody can be submitted to competency, there has to be reasonable doubt. And I was denied to file a response to the request for, at that time, it was titled to remand for competency proceedings, which the district attorney, Marlin, here said, oh, that was a mistake. We didn't mean remand for competency proceedings, we meant refer. She did that representation in oral court. Because I went to the Nevada Supreme Court based on that remand language that you guys were in fact trying to, you guys meaning the state of Nevada for clarification, the state of Nevada was trying to put me in an institution to have me evaluated there. So this caused me unnecessary paperwork. It was vindictive. This
You say I'm being obtuse, but what are you doing here? What are you doing here in this hearing if you're not being obtuse when you even admit that the state made an error by using the term remand instead of refer? And you went all the way to the fucking Supreme Court about it.
whole process of submitting me to competency proceedings in and of itself vindictive, not only as well as the other violations here. But I did my due diligence. I
mean, if I'm being obtuse, you're being asinine. How about that?
The division is so messed up. All of these psychologists in the Northern Nevada and the Southern Nevada are only certified until December 31 of 2019. I said, well, where's your certification into 2020? I just saw this order now that says it was filed on December 3rd. So if I find that I go to a psychologist that isn't certified into the upcoming year, they could be disqualified by way of the statute because they didn't have the certification when it comes time to testify or to have the evidentiary hearing as to whether I'm competent or not.
So the other issue the district attorney's office raised was first the issue of failure to comply with and participate in the evaluation process, but also your contact with Ms. Williams. I'm looking at the letter now. It doesn't say service of process, and as you...
No, that's the first letter that she refused. The second one does.
Okay, I want you, Kim, again, I'm assuming that's actually you in the chat. I really would like you to try and defend yourself with this kind of mess. When you're saying that I'm being obtuse, the state is being inappropriate, when you're trying to pull something like this. Let's listen in.
That was sent on the mail, that letter. See, you can't do anything based on this, and if you try to do so here to remand me based on these lies, these misrepresentations, without me even to have an evidentiary hearing as to whether this has been done, you'll be proving your bias toward the district attorney because I had permission, and he will tell you I had permission to go there.
Counsel, this letter, and it's a letter, August 10, 2019, original writing date completed August 31st, 2019, which is to Talia Williams, Michael Dickerson, Judge Michelle Levitt, and Paul Dyla from Kim Blandino. It has a certificate of service on the back. Is there another letter that went yesterday in addition to this one?
There is, Your Honor. I believe it's Exhibit 4.
Oh, I'm sorry. Let me see.
And the exhibits can be kind of confusing since the defendant's own exhibits are also attached to that. But
that's why we use the sub-qualifiers.
At that point in time, he dropped off both of them. And I would note that the defendant...
Both were dropped off that day.
Yes, that's correct. And I would note that the defendant is absolutely wrong on the who's going to evaluate it. Pursuant to NRS 178.415, the court is to appoint those psychiatrists or psychologists.
Well, that's not being approved. I can't find this exhibit 4 they're pointing out.
Well, I think that there's 2 exhibit 4s. The first exhibit 4 is a unclaimed property receipt, some other thing, and then the next exhibit 4 says urgent service of process.
There it is.
To Leah Williams, November 25th, 2019.
Okay, we first talked about a letter that he sent to Williams dated around August. Now we're talking about a letter titled Urgent Service of Process to Talia Williams.
But then contains a very similar format.
A very similar format.
Yeah, service of process.
Yeah, service of process. So you are trying to tell me, Kim Blandino, that you are going to send Williams the same letter that you sent before, slap service of process on the title and call it a day and make it seem like it's an official document that would conform to the rules and formatting of service of process, and then you want to talk about how the state is being dishonest? You want to talk about how I'm being obtuse? But then you try to pull that shit that any attorney would get smacked the shit out of if a judge saw an attorney try to pull that mess? Spare me. Spare me, Mr. Blandino.
So it wasn't a letter. So now you've proven my point that he lied. He said it was a letter. It was service of process. This is a skilled district attorney here, grandson of one of the most famous and important and man of integrity's district attorneys that were formerly his grandfather. And he sent and lied here and said it was a letter. He knows the difference between a letter and service of process. And this is clearly marked service of process. And again, if I would not have been told that I had permission by my house arrest officer, I never would have gone there. So they can hardly complain that I'm not in compliance. I asked my house arrest officer. I waited for the call. You can't call him directly. You call him,
What's
leave
your
a message.
request, Mr. Blandino, today? Do you want me to remand you?
No.
Okay. Why?
Do I want you to remand me?
Yes.
What is that Shakespeare? How do I love thee? Let me count the ways. There's a 94-year-old World War II vet there. Everybody in this courthouse knows her. Evelyn Pendergraft. She's a great woman. Wonder Woman, the movie could have been made after her. I'm her caretaker. I have brought her here, and I have a duty to her. I made a promise. She's a widow, and her only son was killed by Nevada University Medical Center wrongfully. There was an autopsy had to be done.
Okay, so we're getting...
But anyway, I have to take care of your... But you said, why do I not want to be remanded? That's number one.
Okay.
I need to take care of this woman.
All right, this is what I'm going to do. I am going to issue a written order today that within 7 days from today, 7 days from today, in writing, you are to contact Doctors Claypool and Slagle.
I'm sorry.
Hold on.
With the names?
Claypool and Slagle.
How do you spell
Make
that?
an appointment. You'll get it in my written order. That will issue by 5 o'clock today. That will be filed into the case and you will have access to. I'm not going to grant their motion to remand. However, I'm going to see you back. Not next Friday, the Friday after. And we have better have those appointments made, and I want verification from the doctors that they're done. In addition to the requirements of your release are the following. You will not contact Talia Williams privately or in her professional capacity.
Will that be part of your written order?
Yes.
Thank you very much.
Yes.
In addition, you are not to contact Judge Levitt privately at her home, Judge Delaney privately at her home in any way.
I have no reason to do that.
Well, I'm kind of worried because you're talking about burglaries at people's houses and their addresses. You're not to contact me.
Why
You're
are
not,
you using those representations against me now?
Yeah,
That's
I am.
ridiculous.
Yes. And I'm going to use...
You dare use those representations against me? Yeah. Yeah, I am.
Williams would have had a drop backs in this courthouse. I would have dropped it off there.
Stop talking.
I'm sorry, Judge. This is outrageous.
No, I'm sorry. I do not want you to contact anybody in the Justice Court at their private office, any judge sitting or any judge pro tem at their private office. This is a condition of your release.
Can I have an option? Is there a way I can get it to the courthouse and then they deliver it then if it's service of process?
No.
So I have no drop box or anything
No.
to do any communication there.
No.
No.
This is
Even if
not,
it's- if it-
and I'm ruling today that this is not service of process. This is a letter.
Pay attention.
You have named it urgent service of process to Delia Williams, November 25th, 2019.
Right.
For a number of reasons. It is not the format of service of process accepted by the 8th Judicial District Court or any Nevada court. I am very concerned about the nature of it. It seems very similar to your letters that you've done in the past. It is not service of process. The title is not dispositive, all right?
The title is not dispositive.
I don't want you contacting them, all right? Privately at their house, sending them letters about anything at this point until Judge Levitt allows you to, or another district court judge allows you to serve process. Okay?
Why is it Judge Levitt, may I ask? Why isn't it you? It seems like you're part of this case here.
I'm sitting in the competency case, all right, to make these determinations.
So you're saying you only have jurisdiction over the competency issues?
That's not what she said.
I'm not saying that. I say today I am hearing the competency issues, okay?
Well, now you're addressing my custody and the conditions of the
Yes,
custody.
because I'm not remanding.
It sounds to me like that you're admitting
Yep.
that
I'm not
would be
going to
Judge
argue.
Levitt's
I'm not going to argue with
purview.
you, Mr. Blandino, and I don't like raising my voice.
I need to stay of this order to...
I never said, from the very beginning, Mr. Blandino, I never once said you were a sovereign citizen. I think I said that from the very, very, very first video that I watched. You are not a sovereign citizen. You are, however, of a different kind of vexatious litigant.
To ask for a petition to the
No,
Nevada Supreme
denied.
Court. If not, I'm going to have to make an emergency petition to, because what you're doing here, outrageous, giving that short a time fuse on whatever written order you're concocting here, or attempting to concoct. Because, and what about the permission to file a motion to disqualify? You're denying me meaningful access to an unbiased adjudicator by saying I can't file any such motion.
Without...
Are you aware?
No, she didn't. No, and she's going to correct you, but I want to say it right here. She's going to say it out herself. No, she did not say that. She didn't say that you couldn't file a motion to disqualify. She said that you needed to get permission from the chief judge first before you could file that motion because you are currently a vexatious litigant and you need that permission. That's what she said. Stop being dishonest. Stop being dishonest.
The gravity of what you're doing here?
Without permission and written permission of a district court judge, consistent with the vexatious litigant order that's already in place. I think that if you construe that document as a service of process, that it may have been contrary to the vexatious litigant order that's already in place, and it concerns me. I am going to tell you.
It wasn't filed. Vexatious litigant only applies to filings.
I am extending it to serving judges.
Wait a minute, you're telling me for clarity, you're extending the vexatious litigant order?
No, I'm making it a condition of your release.
Oh, I
that
see.
you don't contact these judges
And
unless you have specific written permission from Judge Levitt, okay, or any other district court
But you
judge.
seem to be admitting that you don't have the jurisdiction here to hear
Thank you,
these
Your Honor.
custody
Thank
issues.
you so much. Thank you, Mr. Bateman.
Status check date will be
I
December
object, and
20th
this is a
at 10
continuing
a.m.
objection
you.
for the record. I object to these proceedings.
Madam Clerk, what time? The 20th, you said?
10 a.m.
It's going to be 10 a.m.
Is this it?
Thank you, Glenn Serio's Trollbot for the $2 super chat.
Send that the doctor's name. She said she was going to do the thing.
It's in the written order.
That's not an order.
The order, she said, you can pull up on the line.
Oh, what is this, December what?
20th, 10 a.m. you'll be
That
back.
paper wasn't complete. It looks like you can see. I know mine. I got these.
Shoot, you gotta be worth something.
Oh, here's mine.
Now we're at December 20th, and guess who hasn't complied with the order just yet?
Yeah.
Yes, 21.
Mr. Jackson, you can't watch it.
And Wendy now.
Yes.
Oh, okay, let me get my,
No, you don't, sir, just come
Mr.
on.
Blandino, come up. You don't need your thing.
I'm gonna go like 2 weeks. So,
I've got a World War II vet that came out here to see these
All right, so,
proceedings. She's
Mr.
94 years old. Can I have her come into the courtroom?
Mr. Blandino.
Could I be given that courtesy, please?
Mr.
No.
Blandino, this is gonna take 1 second. Mr. Blandino has a motion to recuse me. I'm not hearing this case. Judge Marquis, and others that is pending in front of Judge Galani. I just want to continue this a couple of weeks because I would prefer not to drag yet another judge into this matter. So,
And I need to make a record.
Okay, so now she's saying that naturally, Blandino filed a motion to disqualify her, and so we're continuing the hearing.
And I insist on making a record.
We're going to pass it 2 weeks. We'll see you back in.
I object. I have a right to make a record. There's been a fraudulent document and a crime committed in filing this motion to disqualify. And I have a right to get that on the record so that I don't face possible criminal charges.
Sounds like Mr. Blandino should go file a police report at the police department. It has nothing to do with these proceedings today. Those 2 weeks should allow him time to go get those psychiatric evaluations that he has to get, or else he's going to have to be remanded. That's the state's only position that we can have.
No, he's making representations. I demand to make a record.
I'm not hearing from anything from anybody. We're just going to continue this.
I demand, you don't have to.
Thank
I
you, Your Honor.
demand to make a record.
We're done.
I demand to make a record. Drink.
January 3rd, 10 a.m.
I object to this.
I object.
And it's a continuing objection.
Continuing
You don't have any
objection.
business being on the bench in this case in any event.
Which is why I'm not hearing it.
Which is why she's not hearing anything. She's continuing the matter, you dumbass. God damn it. Fuck.
I need a copy of that jazz today.
For fuck's sake. If you say that she can't hear it, she's not hearing it. She's continuing the fucking matter.
Anyone else ready on anything?
We're ready, Judge. On page.
Versus Ken Blandino.
And now we've come fucking full circle. We are now back to the very first video that I watched with Mr. Kim Blandino.
Good morning, all right, thank you. I'm the Brittany Bell. My name is Christina Silva. Good morning.
Christina Silva?
Yes,
You're a district court judge of this district?
I am. I was appointed earlier in 2019.
Do you have a written request under DCR 18 to appear?
Yes, Patty, the one that sent me down this rabbit hole.
I'm going to start to ask some questions, and then I'm going to turn to you. I'll have some questions for you specifically, so hold that thought. Mr. Dickinson, do you have an update for me?
Yes, Your Honor, this is the 8th time that we've appeared in competency court with the defendant. To this date, he has failed to get any of the required evaluations that he's been ordered to
I
get.
object.
He's also seems to have harassed the psychiatrist and psychologist who he's been referred to.
That's a lie.
This is an
Mr.
issue.
Blandino, you'll have an opportunity to talk, let him finish
Can
putting
I
it
tell
on the record, and you'll have an
will I have
opportunity
a
to
chance to
talk.
represent that he's lying?
Hold on, Mr. Blandino, let him finish talking, and then I'll talk to you.
And I base that off of emails that I've received that are coming to the court regarding the way that he's showing up at their offices and refused dates that he's been given by them to come in and evaluate. With that, I think that the only way to remedy this issue is just by putting him in custody and having him evaluated in custody.
Thank you, Dr. Joker, for the $2.
He has multiple times to have the defendant placed in custody to be evaluated, in addition to the fact that he's continued his criminal behavior of illegally contacting judges in an extortive manner while he's been out and in competency court in this case.
So the state is saying that he has not abided by the previous order from December 3rd, saying that he's required to have appointments with 2 doctors, psychologists or psychiatrists, before the next hearing date, and further that he keeps on contacting judges in the same manner that he's been contacting the Pro Tem Federico and Pro Tem Williams. And so now the state is once again asking the court to remand Blandino into custody to get these competency evaluations done.
So with that, Your Honor, the state's request is just to remand the defendant today to get the process moving.
All right, thank you. Mr. Blandino, why haven't you gone to the appointments that were scheduled for you?
I have. I've gone. I've got a card here. They refused to see me. They said they couldn't do it within the time frame that you allotted. He's lying 3 times over, and I'm going to file a bar complaint if he doesn't give an apology.
Of course he does. Note that that's literally what he wrote in the letter that he's being charged with extortion for. Part of it. Part of what he demanded from Judge Federico was an apology to Kim, or else he was going to file a judicial ethics complaint. Now he's demanding an apology from the state prosecutor, or else he's going to file a bar complaint against him. This is how Blandino operates. This is his modus operandi.
Lied when he said he tried to have me remanded. He put pressure on my house arrest officer to arrest me before coming to court. Then when he tried to have me remanded, when I say he, district attorney's office, but Michael Dickerson is an embarrassment to the bar. And I have showed up at all the requirements. As a matter of fact, the order that you see by Linda Marquis ordering me to go within 7 days and make an appointment, I was there I called that very moment I got home and then went to their office at 3. Now he wants to take my appearance at their office as somehow some bad conduct or bad acting.
Well, Mr. Blandino, did you have an appointment or did you just show up?
I told him, look, I wanted to see the office and then see you, and I want to get this appointment scheduled as soon as possible. They said, we can't do anything until we talk to the doctors.
Okay.
At 3 o'clock when I went down there, and I have this all documented. I've got a copy for the DA and I have a copy for the judge, and I demand that you take judicial notice of this, because if you go ahead and do this horrible thing that he's recommending be done based on lies, then here's the DA's copy.
Well, Mr. Blandino, hold on. Let's back up a little bit. So you went down there without an appointment. Is that correct?
No. The judge told me
No. Answer my question. You went down to the doctor's office without an appointment because you were trying to get one. Is that correct?
Yeah.
Well, yeah, but I called first, and then I said, I'll come down at 3 o'clock. She made no objection. She said, no, don't come down here or anything. Went down there. I've got a witness in court right here, Chris Cave, that acknowledges that. He took business cards and such, and in good faith, I wanted to see that the office was clean. There weren't any health violations or anything such as that, and it was what I was going to appear for an appointment. Then I scheduled an appointment for the 26th. Everything seemed good. They emailed me, and I've got a copy of this stuff. Now this is labeled me, but here's the emails back and forth. If I can approach?
No.
No, you cannot.
Can the bailiff bring this to you?
No.
Sure.
Yeah. This is an email, and then this latest card. They didn't formally tell me this appointment was canceled on the 26th, so I went down there, and now he's again, the district attorney's trying to again say that this is somehow bad behavior on my part. This is absolute due diligence on my part to make sure that they comply with what they were ordered to. But they're telling me that because this court, by order, gave a 20th date, they can't help me. So
Okay, hold on. Now let me review the documents you gave me, all right?
Okay.
So hold on.
You give me an order to appear?
Mr. Blandino.
Oh, I'm sorry.
Please wait until I'm finished
Okay.
reviewing the document. Thank you.
You do have the marquee order, right?
I do.
Okay. Thank you.
Thank you, Doctor, for the $2 super chat. Kim equals Karen.
I was precluded from...
Mr. Blandino, hold on.
I'm
I'm
sorry.
review.
I've got other documents.
Mr.
too.
Blandino.
Yeah.
Shut the fuck up,
Hold on.
please.
Well, I'm trying to stay out of jail. Excuse me if I'm a little bit...
And I appreciate that, but you're not going to do yourself any favors by not letting me finish reviewing this, okay?
Yeah.
is with what appears to be an individual with the state of Nevada, specifically the Lake Crossing Center. I reviewed a second email to Green Valley Psychiatric Associates. It seems to be kind of a cut and paste of a couple of...
Well, it's all the replies.
Hold on. A cut and paste of replies with an email exchange that previously went on in the month of December.
Yeah, just for clarification, though, it's not cut and
Let me
paste.
finish putting this on the record. Which attached to that is an order, the order that Mr. Blandino was referencing for the defendant to be examined.
Yeah, sometimes other people want to place things on the fucking record, not just you. God damn. I can tell the alcohol is getting to me because I've lost all patience with Mr. Blandino at this point.
I also have a copy of a business card with a note that Mr. Blandino showed for an appointment on 12/26 at 7:45, but the appointment was canceled due to the time limits of the report being due on 12/20. And attached to that is an email exchange between Mr. Blandino and an attorney for the court, Mr. Liescas.
Yeah, he's staff counsel for the administrator's office.
Okay.
They, Denise Baker and Denise Parker of the specialty courts said that I would have to communicate to them. They refused to communicate with me. I've been absolutely due diligent on behalf of my client, which is me, Kim Blandino, as I'm representing myself.
Okay,
As an
well,
officer of the court,
let me ask you this question.
Yeah.
Why did you not go to the appointments on December 11th and December 16th?
they never sent me any appointments for those. Where are you seeing the appointment for December 11th, December 16th? They never sent any appointments.
Well, the information I have is that you declined appointments on December 11th and December 16th. And I don't know if you declined them
No,
or
no,
you
no,
just
I did
refused
not.
to be evaluated. All right, so let me ask where that information is coming from. Hold that thought. Please don't interrupt.
So here's the point of contention right now. The order that was given to him on December 6th was that within 7 days, Mr. Blandino had to have gotten appointments with two doctors, either psychologists or psychiatrists, and have them done before the next hearing date on December 20th. Obviously, we now know that December 20th hearing was continued because of the disqualification. Another part of the allegation here is that Blandino was given appointment dates of the 11th and the 16th. Blandino claims he was never given those dates. The state is claiming he was, but Blandino told the people making the appointments that he couldn't make those dates. And therefore, the clinic or wherever he was getting these dates gave him a date of the 26th. But apparently at the date of the appointment, the folks there said, well, I mean, you're already past the 20th deadline, so there's no point in having the appointment, and to take it up with the court. Again, the contention is that Blandino claims that he was never given the 11th or 16th as potential dates of these appointments.
Mr. Dickinson, do you know where the dates of December 12th and December 16th came from?
I believe those came from the staff or the doctors that had emailed the court and let the court know that we offered Mr. Blandino, or they offered Mr. Blandino those dates. He said those dates wouldn't work for him.
This is not true, Judge.
Right. So the state is claiming that when he was given those dates, Blandino said that those dates wouldn't work for him, and therefore they gave him a date for the 26th. However, obviously the 26th is well past the date of the return hearing date of the 20th.
Hold on, like I said, don't interrupt. Let me ask, and then I'll ask you your questions.
That's my understanding of that situation.
All he has is hearsay to go on. And if you're going to put me in jail, I demand an evidentiary hearing because I can get those people on the stand and verify. If they had given me those dates, I would have definitely filed an emergency petition with the Nevada Supreme Court to try and stop this. But if I couldn't get it, then I would have
Well, that
complied with
doesn't
those
make any
dates.
sense. Why would you file an emergency petition if you were ordered to go get an evaluation done and then were ordered to
Oh, well,
go
it makes
to-
perfect sense if you understand the double jeopardy clause of the United States Constitution. I've already been punished. I've got this ankle bracelet on here, and I've been under punitive house arrest. I've been punished for the very crimes that I'm being charged with.
No, you fucking aren't. And I remember talking about this the first time I watched this video. No, you're not. The house arrest It's a condition of your release on bond. It's so that you're not being placed in jail until your time of trial. So do not give me this fucking mess that it's a punishment. It's a privilege that you are out in society and not in jail until your time of trial, dude. So do not give me this double jeopardy punishment bullshit.
Now, under Desimone 2, which is Desimone versus State, come back from the U.S. Supreme Court, if you have been punished already, you cannot be punished again, and therefore...
I'm sorry, you're going to have to give me some fucking solid case law that says having conditions on your release prior to trial is in violation of the Constitution, including house arrest. I'm calling bullshit on you, sir, until you could provide me some substantive case law saying otherwise. Do not give me that.
It would moot any competency proceedings or even any charges going forward. I've been denied my religious beliefs and practices to take E.V. Pendergraft on religious excursions because I'm not a member of an organized religion, Mormon, Jehovah's Witness, you name them, Catholic, whatever. Because I have particular and peculiar religious beliefs and practices, I've been denied to take her. I'm being treated worse than if I were in the Clark County Detention Center. There's been
Okay, so I'm sorry. This is the last time I'm going to interrupt to answer Blandino in the chat. Please tell me, I want you to tell me that being under house arrest is the equivalent of being remanded into custody until the time of your trial. Please tell me that being placed under house arrest with the high setting is the equivalent of being in jail until your trial date.
Action here. I've got a 6 p.m. to 6 a.m. curfew. This statute has not been reviewed by the Nevada Supreme Court or the federal courts, but this statute where a judge is allowed to put somebody under punitive house arrest prior to being convicted in any way will not stand constitutional scrutiny. And I can show with all the documentation, as you can see from those emails, I document what I do. And that email that you cursorily read, it doesn't say anything about an 11th or appointment. They said we can't.
No, Mandy timed him out. Mandy, you didn't need to do that, but I also understand why you did it, so don't worry about it.
Do it within the time frame. They never told me about those appointments. Not once. I don't know where he's getting that information. I know that Mr. Dickerson has lied to this court before. He said when he tried to have me thrown in jail the last time that I told my house arrest officer I was going to drop off some process with Talia Williams, who was the pro tem judge in the Justice Court. And I asked him, and he gave me permission to go. If he would have said, no, Kim, you can't go, I would not have gone. But yet, he lied in open court. Now, maybe based on hearsay that he was taking.
This defendant right here is on house arrest as a privilege.
I understand, Mr. Dickerson, I understand that, but we're also not...
Exactly. The state said it right there. Being under house arrest is a privilege, not a punishment.
Engage in a back and forth.
I'm on house arrest and $50,000 bail.
You and everybody fucking else facing criminal charges, man. You are not the only one out there. Fucking hell.
Happens, Mr. Blandino, when it comes to court proceedings and.
But I'm saying this court has never approved that. They've never reviewed that. And you have surprised me, Judge, because I thought Linda Bell was going to be here on the bench here. I have a right under NRS 1.230, 1.235 not to be surprised by a judge. I don't know if there's any conflicting issues on which I might need to file a motion to disqualify against you. This motion to disqualify has not been adjudicated yet. Do you see on the record anywhere that it's been adjudicated?
It has not, but I'm not Ms. Bell. So hold that thought. Mr. Dickerson, is his house arrest officer present in the courtroom?
I don't believe so. Arrest officer's present.
Do we have any information regarding any house arrest issues?
Well, we addressed it at the last hearing, or 2 hearings ago. We filed a motion to
Mark, he denied that, though, on the record, Judge.
Hold on, but I'm asking for some history.
If you're going to ask if
Mr. Blandino, I'm gonna ask you to please be quiet, because I need to answer some questions, so
I'm
we
sorry, I
can address your
apologize.
case, all right?
Essentially, the issue was that Mr. Blandino had told his house arrest officer that he was going to go to an attorney's office to drop off some paperwork.
Right.
What it sounds like he didn't tell his house arrest officer was that attorney was the pro temp judge that was sitting in justice court over his case, and the paperwork that he was going to drop off with her was extorted paperwork similar to that is at issue in this case.
And was that motion to remand denied by Judge Marquis?
It was denied in the written order. That's why I asked if you had that marquee order.
I'm going through the docket, Mr. Blandino, but I need you to stop interrupting me. We'll make this process faster. Was that denied, Mr. Blandino?
I don't know who he's gesturing to, but he's gesturing to people to get some water because obviously he's been talking a whole fucking lot.
Denied with additional conditions added to his release, that being no contact with Williams, no contact with any judge privately, no contact with any judge without express written order by the.
Thank you very much, Sonia, for the $10 New Zealand. Take care.
District court approval.
Was he declared a fictitious litigant at that point?
He has been previously.
That is on appeal with the Nevada Supreme Court, case number 76794. Briefing has been initiated by me.
It's been dismissed. Spoiler alert. They dismissed his action in Supreme Court.
Waiting for a decision. The responsive brief is not due unless the Supreme Court so directs. Because of that vexatious litigant order, I've been only able to make representations orally in this court, except in the unique exception where Judge Levitt allowed the motion to disqualify to be filed. But when I went before Marquis to file it, she wouldn't receive it in court, was not file stamped. To this date, it's not file stamped, which caused me to file this or submit a notice.
So, Mr. Blandino, did you attempt to contact Judge Marquis after that hearing?
No. Well, no, I submitted the motion to disqualify, as the vexatious litigant order says, to the chief judge. Now, I relied on the chief judge, his law clerk, Wes, who took over for Benjamin Nemec. And I said, hey, look, I want to see if I can get approval to file this. Unbeknownst to me, he went and filed it without bringing it back to me because the certificate of service was signed in advance, figuring I'd be able to file this in open court. And this is the part of the problem that we have here, Judge. Every one of you judges are showing favoritism toward the district attorneys. You let them file stuff on the very day of court. I get 5 minutes to look at it. That remand thing was given to me about 10 minutes before court. I got a cursory view of it, and then the judge rules on that without allowing me to do any kind of opposition. This motion to disqualify, I put in a notice. It's still under review. Wes couldn't tell me yesterday, that's Judge Bell's law clerk, who's reviewing it, or when, or under what criteria. The Sullivan versus District Court is very clear. When I put this thing in, it has to be marked received, which it wasn't. We have no chain of custody as to this document. It was filed by someone else other than me. Of course, I'm restrained from coming to the RJC, except when I have court appearances. So, I mean, there's just a slew of problems here because as representing my client, which is myself, I have to be zealously and vigorously defending requiring due process to be followed substantively as well as procedurally. The U.S. Supreme Court has said over and over again, procedural due process is every bit as important as substantive due process. So, to protect my client's rights, I'm going to demand that the court and all the officers dot every I and cross every T because this protects others that come from behind me. Now, Miranda, he wasn't a good guy, but the Miranda warning we have is due to a guy that said, hey, I was abused in my rights. And there's something in the Constitution that mandates that. However, you know, apparently the problem is, if you see from that card, they said they were unable to comply with the 20 dates. They were unable to comply, Judge, what you were just given. It didn't come down to any misbehavior on my part. So he's trying to shoe in, the district attorney here for the record, is trying to shoehorn in somehow that I had 11th and 16th date and make me look like I'm not diligent in what I've done. And then when I am diligent, go down to the office to appear to show, hey, here I am, ready, what do you want to do?
I think we all know that he's being completely disingenuous when he's talking about, oh, but I appeared here at the office to, here, where's my appointment? When we all know that, that's not how appointments work. You don't go there the same day of the hearing and then expect to be heard.
He tries to interpret that as misbehavior, like I'm harassing them.
Okay, hold on, Mr. Blandino.
It's damned if you do, damned if you don't.
Mr. Blandino,
Yes.
listen to me. The challenge is, and based on my review of this email exchange, you want to set your competency evaluation based on the dates you want to go and at the schedule you want to set it at.
Exactly. You don't get that levity when we are now in December. Bear in mind, the motion to refer him to competency was back in September. We're now in December. And now he's complaining that, oh, well, he only had such short notice to get appointments. Dude, you lost that leeway when you kept on delaying this entire process.
And that's just not, and
No, that's not true.
Well, I'm looking at this and there's multiple contacts. You admit in this email, as an example, that you made multiple phone calls wanting to be seen. You hadn't heard back. It had only been a day since you placed the call. You were submitting repeated phone calls based on what I'm interpreting here. It's a little bit difficult to read some of the things that are submitted.
Yeah, then that's why an evidentiary hearing, if you go to put me in jail without an evidentiary hearing, you will be violating fundamental due process because you're trying to make some kind of factual determination based on this and not the evidence of the witnesses and evidence that could be produced at any evidentiary hearing. I tell you that I did everything due diligent without being harassing in any way. They never gave me those dates. If they would have given me those dates, I would have complied with those dates and or asked for an emergency petition from emergency motion from the Nevada Supreme Court to stay this because of my double jeopardy claims. Now, they gave an order, Judge Marquis gave an order that I was supposed to do one within 27th day, but you see that card shows that they were still locked into this somehow, this 26th date. Somehow Marquis didn't get the order down to them or something because...
Bullshit. Bullshit. Okay, I did. You know, it's he said, she said as to whether or not Blandino was told about the 11th and 16th dates. I'm sorry, but based on his current actions leading up to this point and all the previous history, I'm disinclined to believe Blandino when he says that he was never informed of the 11th of the dates offered of the December 11th and December 16th. I'm sorry, I'm not buying your arguments here, Mr. Blandino, given all the previous history.
I complied with what they said. They never reset any new appointments. Now this was at the December. What was the date on that card there?
On the card.
Well, I'm sorry, on the date of the Marquis order. Because see, that's the thing. If you're going to do this based on representations by the DA, he's lying, and I want him on the stand to show that he's lying.
You need to stop.
This gave me 7 days.
Mr. Blandino, listen to me.
I'm sorry.
I need you to stop making accusations that he's lying. Your train of thought is very difficult to follow. And so you're jumping from one thing to another. So I'm trying to keep us on track here.
Okay, here's what the order said.
I have it right in front of me. I see it.
It says within 7 days.
Mr. Blandino, I can read it.
Yeah.
I understand it says within 7 days. So
Yeah.
hold that thought. I have a question for Mr. Dickerson. Okay?
Yes, Your Honor.
So I'm looking at the email exchanges. What evidence does the state have regarding his failure to comply with that 7-day order, other than he declined appointment?
What I have is that we were in court in front of Judge Marquis on December 6, 2019. She told him at that time that he had to get these.
Objection, Your Honor. This is irrelevant to the December 20 order.
Mr. Blandino.
I don't have a DeLorean with a flux capacitor to go back in time.
I let you talk. I'm going to let him talk.
Okay, I'm sorry. I need some water though, Judge. I'm not counting.
Okay, we'll get you some water. Hold on.
She told him at that time that he had to do the evaluation within 7 days. Then I currently am looking at an email right now from Green Valley Psychiatric Associates to the court that was discussing Mr. Blandino. Specifically, it talks about how he had come into the office. He came into the office on December 6th, the day of that.
I'm sorry, objection. Why isn't he giving you to read it?
Mr. Blandino, what did I say? Please stop interrupting. It will be faster. Let him finish talking and
calm down.
Then you'll have
Yeah, but you're relying on his representations of what the email says.
I'll take a look at it in a minute.
I object to that.
I object to that. Okay. KF Wells, thank you for the $5. If this wasn't real, I would think this to be a stage show to display to future lawyers how not to behave in court. I agree.
And this is an email that the court has received, the court's administration, Your Honor. December 6th, ultimately, the exchange goes on there with obviously that not being the appropriate way to schedule the appointment. On Monday, December 9th, they contacted Mr. Blandino, told Mr. Blandino that they had December 11th available for him at 7:45. That was left in a voicemail. He called him back later that day, told him, no, that's not going to work. They said, well, we could do December 16th at 7:45 in the morning. He said he didn't want that one either. And then they told him the next available that they had was December 26th, 2019.
So now he admits that he was aware of the initial date of the 11th, but he just said right there, but I couldn't make that one. He doesn't really give an explanation as to why he couldn't make that date, but now he admits that he was well aware of the initial appointment date of December 11th, which again would have been within the timetable of the December 6th order. Thank you, Nahalito, for the $5. Found you because of the Saga. Stay for the amazing commentary. Thank you very much, man.
Which he was aware of at that time was after the December 20th date that was due for those particular reports. Well, that's the one that he decided to go for. I think it just shows exactly what the defendant's doing here. He's trying to drag this out. He's just trying to take this process and make a mockery of it because he thinks that he can run it the way that he wants to, but he is disregarding the court's order after order.
Mr. Dickerson, can I see that email you're referring to? For some reason, I don't have a copy of that.
Yes, Your Honor. If I can
I object. I need a copy of that too.
Forward it.
I need a copy of that too.
Yeah, we'll print it
But
out.
look at this, Judge. He's going back in time to irrelevant matters. The December 20 is what's controlling here. It's irrelevant as to that. If he wants to make some prior bad acts claim, I object to that. This is what's at issue here. Obviously, the judge, I told the judge, I need a written order as to what I'm supposed to do. The evaluation process, which apparently attorneys throughout this entire 8th Judicial District and maybe even beyond, think that somehow they should, it's in the interest to waive their client.
Except, Mr. Blandino, we all saw what happened on the 20th. On the 20th, the judge didn't make any determination because you had filed a motion to disqualify. So there was nothing ordered on the 20th. It was continued to this current date, January 3rd. So your claim to say that the 6th order was irrelevant and that the 20th is controlling is meaningless because nothing was determined on the 20th. It was simply continued. Now who's being dishonest?
Rights to have a written order signed and filed by the judge. This is a court of record and a court of justice. As a court of record, I'm entitled to have a written order that says specifically what I'm required to do and when. And if I don't have that, then I'm up in the air because Rust versus Clark County School District is clear. An oral pronouncement from a bench or a minute order is incompetent for all. I'm using the wrong word. Incompetent is wrong for is not viable for any purposes. Has to be a written file order. So when Judge Marquis agreed with me apparently and gave me this order the same day on December 20, there's no possible way I can go back to December 11 and December 16 to make those appointments. So clearly, this is vindictive on the part of the district attorney's office to try and claim that those activities, which there was no prior written order, and I had a right to, because if I'm in contempt of an order, under NRS 22, order to show cause has to be made. It has to be done upon affidavit, sworn affidavit, not from lies from the district attorney's office made orally. There has to be a charging document for a contempt to be done. I went down there. They said, oh no, we got a December 20 order. So somehow they didn't get a copy of this. Because I tried to make, in good faith, make an appointment. I thought, well, maybe that 26-day appointment was still good and I can go make it. So I said, I better show up. Because otherwise the district attorney's going to lie and say, we didn't even try and make the 26th
Hold on, I'm
appointment.
going to review this email.
Yeah, I need water desperately. I got cotton mouth.
Are you a doctor? Are you a doctor? Want to see friends? Don't see I don't see friends.
Don't talk to him.
I know you. Okay, I'll talk to you. You can come if I tell you.
It's distracting.
Okay, whatever.
Can I get a copy of that to read? I need that water really badly.
We're getting you water, Mr. Blandino.
Oh, thank you. I didn't hear that.
Yes, so hold on.
I know the court has a busy day, so when I speak so fast, I get cotton mouth and the adrenaline doesn't help either.
I understand. I've actually suffered from cotton mouth myself. I'll tell you though, talking only makes it worse. All right.
Thank you.
Is that different? Is yours different? Mark, do you mind? I've reviewed this now. You can provide this copy to Mr. Blandino.
Does it indicate where that email is purportedly from? And I asked Green Valley Psychiatric for any information they had, Judge, and they would not give me anything. I need to know from the back end what shenanigans might be played, especially by this district attorney.
Oh, shut the fuck up.
Who's a disgrace to his grandfather.
Okay, very much shut the fuck up. What the fuck is wrong with you?
Who was an honorable and
Mr.
ethical
Blandino,
man.
enough. This is not a court where we toss around disparaging remarks to anybody. This is a courtroom. We're going
I wouldn't give
to
them the
conduct
warranty.
ourselves with proper decorum in this courtroom.
Well,
And Mr. Blandino, enough.
Oh, I'm sorry, I thought it was...
I'm going to provide you a copy of the email so you can take a look at it.
Who is it purportedly from, Judge?
I mean, honestly, an attorney would get slapped with contempt for a remark like that. Thank you, Reverend Jason Reed, for the $5. I honestly believe a narcissist like Kim could fake his way through an evaluation. I've known too many of them. And thank you, KF Wells, for $5. Spoiler alert, it's been filed against Blandino that his behavior is an attempt to sandbag the judicial process with frivolous claims.
And two. One and two. Okay, this is from Denise Baker. This is one of the specialty court ladies.
Yes.
Well, why wasn't I being sent a copy of this?
Because it's a court proceeding, Mr. Blandino, and you're not a member of the court.
I'm an officer of the court as representing myself under a Ferretti canvas, and I object to that. I am an officer of the court no less than
All right,
this bar
Mr.
attorney is
Blandino, take a
here.
minute to review that email.
I am. See, all this
Mr.
irrelevancy.
Blandino, have you finished reviewing the
No,
email?
I'm reading it, but I'm saying this stuff.
Finish reading it, and we'll talk about it.
This stuff relating to the 1211 is irrelevant as to this December 30 order. Unless you've got a time machine, I'll go back in time. Now, see, this is not true. If I got her on the stand, she would not say he didn't want that one. I asked if there was another one, and I had a conflict with that. I told him next available hearing was this 12/26, and that's the appointment that was made. The due date for the next report is 12/20. She never told me there was a problem with that. Just because there's a status check doesn't mean they can't set the appointment. You know that very well, Judge. And the defendant knew he would not be seen before his... Now see, she's testifying here. If this is going to be introduced as some kind of evidence, I mean...
She's not testifying.
This is more bogus than the Trump witch hunt impeachment.
Oh my fucking God.
I told him the next available date that Dr. Capel had was Thursday, the due date, and the defendant knew that he would not be seen before this next due date. How does she know what I know?
Okay, so...
Dr. Slagle had no availability. When I said that 12/26, they said they call me back, and they'll make an appointment with Dr. Slagle. Courts do continuances all the time to fit schedules.
Sure. Hold on. All right. So...
Part 2.
Mr. Blandino,
Don't worry, it's shorter than the first one.
I'm going to put some things on the record. You're referring to December 30th order, and I don't know what order you're referring to.
No, December 20 order. This is the Linda Marquis order.
Well, the order...
Oh, I'm sorry. You're right. It says for a status check on December 20.
That's right.
But it
so
said
it's
December
actually
6th.
a December 6th order.
Yeah. Oh, you're right. I been goofed up. I apologize.
No, that's okay. It happens. But
I did set those appointments in this email.
Okay, Mr. Bundy, let me finish putting this on the record, okay?
Yeah.
So this is a December 6th email where Judge Marquis put a number of things on the record and made a number of findings. Of importance to what we're here for today, it specifically says on page 2 of that order, paragraph number 1, that within 7 days of this written order, Mr. Blandino shall make evaluation appointments with Dr. Capel,
Which is undisputed I did.
or Dr. Slagle, and he can contact them and they provided the contact information.
Which I did.
I also find that that office attempted to schedule appointments for you for both December 11th and December 16th. But you advised as you said here in open court, you were, quote, not available for the December 11th date, and you provided no reason why you couldn't be seen on the 16th. Instead, you decided...
No, I was never told about the 16th, Judge. All I was told is that I had an appointment. My recollection now is that I had an appointment for the 26th, and they told me over the phone. I wish I'd recorded that darn thing. But I didn't.
Well, that would be another crime, so don't do that.
Yeah, but if I would have law enforcement there, because there's a potential crime in progress, especially if you put me in jail, that'll be a compounded crime. They said the 26th, they said, we'll call you later to schedule the one for Dr. Slagle. So at that point, when I hung up the phone, I thought everything was fine and dandy. The email that I showed you shows you that says, and it's not a cut and paste, it's just what's called a continuation, where you got REs back and forth. And it says that we can't do anything for you by the 20th date. You're going to have to work this out with the courts. Do you see that? Now, I was denied to present this information to Judge Bell last time, just to make a record, even though she had no business being in on the case. But because I'm being denied these rights, especially to make a record, it's very, very tough to do this.
Well, I do find that there was an attempt to have you go in on December 11th, and I still have no reason as to why, other than your representation, that you were unavailable, but you don't have a reason.
No. See, this is not a static conversation where it's text back and forth. I said, is the 26th good? And they said yes.
That was good because they had an availability, but to comply with Judge Marquis' order, it had to be before the 20th.
No, that's not true.
Exactly. Just because they had an open date did not mean that you were complying with the December 6th order, which is far more important than the availability of the clinic.
The order. This matter is on for a calendar for a status check on December 20th.
You're right.
So if I would have come in here...
Actually, it would have been before December 13th.
It doesn't say the evaluation had to be done by that date, Judge, and you have to know that it could very well, I could have said, hey, look, I got an appointment with Judge Capel for the 26th, and then a Judge Slagle on so on and so forth, and whoever was sitting on the bench could have said, okay, yeah, that's fine.
Let me ask Mr. Dickerson a question about that, because the order actually does say, Mr. Dickerson, that he has to make evaluation appointments within 7 days of the order.
Exactly, and I was in total compliance with that.
Mr. Blandino.
Yes.
So the ruling from the bench was that he had to get the evaluation done within 7 days.
No, that's not true. It doesn't say that.
Those are the notes that I have. And that's what I'm showing.
Yeah, don't go by the judge's signature on a signed and filed order. Go by his note. Yeah, so this is America.
Ultimately, it's quite clear exactly what Mr. Blandino is doing in trying to push this out past the status check. He has no good reason that he's proffered to this court as to why he couldn't attend any of the dates that were offered by the psychiatrist, especially considering that those were dates that were offered for both of the psychiatrists to be present during the evaluation.
No, they offered the 26th date, Judge. I took that 26th date, and they said...
I see that.
And the 26th date was only for Dr. Slagle, never confirmed for a 26th date. So the defendant never actually scheduled his psychiatric.
I tried to.
He's required by statute to have two. So he didn't schedule those within the time required by this order or by the ruling from the bench. Either one, the defendants failed and violated this.
So the state's saying regardless of whether or not Blandino had to get appointments before the 20th, or had to have had the evaluations done by the 20th, Blandino did not comply with either of them. No matter how you interpret it, he failed to comply with either interpretation.
No, that's not true. You're going to take a rule. This is absolutely wrong. I did that quicker than the 7 days. I called up that very day, went down to their office that very day. She said she couldn't do anything until she heard from her doctors. When I called and made that appointment, as far as I knew, the 26th date was fine and dandy. Everything was good. Got off the phone, and they said, before I got off the phone, they said, we'll have Dr. Schlegel make his appointment with you. And so it could have been before or after. If this order would have said, Judge, if this order would have said, you, Mr. Blandino, shall have those appointments set before December 20, absolutely, my client, me, would have done so. It says for a status check. I've seen over and over again where they do status checks, and you go and you remand me like this district attorney wants. You watch how.
Stop pointing. Pointing is, I was taught that pointing is very rude.
I'm slow played through the system. Maybe a month and a half in custody before somebody comes to evaluate me. And will he be complaining about abusing the process? Absolutely not. This mental health system spends less than any place in the country. It's
so now has a vendetta against the fucking mental health system of Nevada. Of course he does.
Under a federal consent.
Thank you, Tones Over. Thank you for the $5.
Consent decree because of the numerous violations that they've done. And I'll tell you what, I was going to do an emergency motion to the Nevada Supreme Court prior to this hearing, anticipating that there might be some more lies here, and I said, no, we'll see what happens on this because they still got the motion to disqualify. You know, you can't sit on the bench, Judge. There's still an outstanding motion to disqualify. You have to know that. 1.230 and 1.235 is very specific. Until there's been a determination on the motion to disqualify, the court can proceed no further, and that includes you.
Okay, Mr. Blandino, so I'm reviewing the transcript from the proceeding with Judge Marquis.
The transcript that I paid for.
The transcript says specifically, make an appointment, you'll get it in my written order, that will be issued by 5 p.m. today. That will be filed into the case and you will have access to it. I'm not going to grant their motion to remand, however, I'm going to see you back, not next Friday.
Now, in case you haven't been following along, I kind of haven't. She's now reading from the transcript of the December 6th hearing.
Friday after. And we better have these appointments made, and I want verification from the doctors that they were done. In addition to the requirement of your release, you are the following. You are not to have any contact with Talia Williams privately or in a professional contact. Your question will be part of the written order. Yes, thank you very much. I appreciate that. And then you were also ordered not to have any contact with Judge Levitt or Judge Delaney. And then there was some back and forth because you continued to interrupt the judge. Okay, so specifically again, the judge said, we better have those appointments made and I want verification from the doctors that they were done. So we're sitting here now on January 23rd.
Now, appointments made, that's key, Judge. If you appoint to that, the appointments were made. I made an appointment that they said was good to the 26th, and I was supposed to get a call back.
Except they were supposed to be done by December 20th.
There's nothing on that order. I was required to do within 7 days, which I did.
And there were supposed to be appointments with 2 doctors.
Correct.
And he knew the whole time that he only had 1 appointment.
Correct. So you can't do 50% of the work, Mr. Blandino, and then be surprised that the court is going to have issue with the fact that not only did you not follow what Judge Marquis said and get those 2 appointments done, not just 1.
They refused to do them. They said it was beyond the 20th date, and I had no idea
Mr.
that there was.
Blandino, stop interrupting me. Based on the information before me, it appears that they attempted to work with you not just on 1 occasion, but 2 occasions, that being December 11th and December 16th, both of which would have been
I thought this was the 16th.
December 11th and December 16th.
16.
Which is what, which would have been before the
I never got a
December-
16th date.
Ms. Blandino, let me finish talking.
Yeah.
Which
Honestly, This judge has far more patience than I would have at this point.
Would have been within not only the 7-day range that was discussed before Judge Marquis, but well before the 20th day that was initially set for a status hearing, where you would have followed the order. We better have those appointments made, and I want verification from the doctors that they're done, that the appointments are done. So, what you did do is you did 50% of the way, and I do give you credit for that. You did attempt to make an appointment, and you got an appointment, of course, all that on your schedule. I still have no explanation or excuse as to why you did not go on December 11th of 2019, which would have been within the court.
Because they gave me an appointment for the 26th. This was a banter back and forth where you're trying to reconcile schedules. The court does this with the attorneys all the time, where you're setting a date. Oh, can we make it this? No, I've got this, I got that. And they said the 26th. Why? You can't sit there and say that I did half the work. I did the entire amount of work. I set the appointment the 26th. I thought everything's fine. It doesn't say in this order that the appointment has to be before the 20th. And so they said they were going to call me back, or Schlegel was going to set up an appointment. Now, it may have been before the 26th or after the 26th. It's up to his schedule. But you're making it sound like I just purposely did 50% of the work and I complied specifically with this order as written.
Now, you also get a sense of how this guy loves to be dishonest when interpreting written orders. He reminds me of litigants I've experienced myself.
Now, if Judge Marquis, wanted to do this and say, your appointments have to be set for December 20th, I would have done that. And I would have gone to the commission, or the Nevada Supreme Court.
You were here in open court when Judge Marquis told you that appointments had to be made and verification had to be done. You received that order that said within 7 days of that appointment, you had to have those appointments made. You didn't do that.
Yes, I did.
On the December 26th date, but it was made, that's well after the 7 days.
You are twisting the facts here, Judge. You are clearly biased and...
You hear that? You hear that crack in his voice? You're biased against me.
You didn't do that.
Yes, I did.
On the December 26th date, but it was made, that's well after the 7 days.
You are twisting the facts here, Judge. You are clearly biased in favor of the district attorney here. I said bias. I'm going to have to file another motion to disqualify you.
And there it is. That sums up Blandino in a nutshell. If anything is ruled against him, he will scorch earth tactics. It's all bets are off. Any ruling against him, it's automatic bias. You have to be biased against him. Anytime he's ruled against. That's his modus operandi.
You're going to need to follow the court procedure for doing that.
Why do you want to only do half the work? There's a motion to disqualify.
Please
You
lower
can't
your
do
voice,
anything in this
Mr.
case.
Blandino, lower your voice.
And apparently he claims that making this oral pronouncement that he's going to file a motion against her is automatically going to stay the proceedings, which again gives away his tactics. He thinks that any time that he makes this contention about a disqualification, it'll force the judge to not rule against him ever.
You can't do anything in this case with an outstanding motion to disqualify.
I am going to grant the state's request to remand Mr. Blandino to custody.
Yeah.
Be taken into custody at this time.
All right, can I? No.
I am going to order that Mr. Blandino also be evaluated while he's in custody pursuant to the pending...
Are you going to give a timeline for that, Judge?
It'll be with in the normal course of the...
Oh, the normal course, which could be 3 months from now until I get evaluated. This is outrageous, Judge. I object to what you're doing. You're taking an evidentiary hearing based on hearsay.
I'm advised by the staff that it'd be 3 weeks. Within 3 weeks, I will be evaluated.
Thank you very much.
Thank you, Your Honor.
All right. Is there anything further the state needs to put on the record? Mr. Mark, is there anything else you need to put on the record?
No, Your Honor. I think that we just need another date. I apologize. 3 weeks? Is that what we're saying? 3 weeks would be best to be able to get those valuations done.
January 24th at 10 a.m.
I just saw that our Nevada judges is in the house. Love your guys' work. Keep it up. Y'all have been amazing by following a lot of these cases.
All right, for the record, Mr. Blandino has been removed from the courtroom. His next court date will be January 24th, 2020. I do find that Mr. Blandino violated the court's oral order back on December 6th of 2019, where he was ordered to get those appointments done and made and verified that they were taken care of within 7 days of that court order. The evidence before the court shows that he attempted to comply, but again, he admitted in open court that he did not go to the December 11th date. He denies that he was ever contacted about the 16th. He provided no explanation or justification for missing the December 11th date, and instead relied on a date of December 26th. While that was somewhat partial compliance, it certainly wasn't full compliance, and it is not the first time, as I understand, Mr. Bland, that he was under any release of...
Okay, so the remainder of this is the judge reiterating what's happened. Blandino's long been held into custody, and she's just stating why he's being remanded, and so on. So, Kit, $192. Kim is checked out from reality some time ago. I mean, maybe. DR Strangelove, $10. Artie is licensed in the state of inebriation. I mean, I can't say anything about that right now. KF Wells, thank you for the $5. Keep him remanded until the next doctor availability sometime in 2023. Well, we won't get to that part. So, we're going to go next.
Pre-trial detainee with conditions which are proper.
Patty, why do all these people tell you to love them in various channels, live streams? It's apparently a recurring meme. I can't, I couldn't tell you, but apparently it's a thing. I don't know why. Now we are, January 24th, 2020. Well, we're gonna find that out, Jassa, real quick. This is the second to last video of the night, so don't worry about it.
Good morning, please be seated.
Please be seated, come to order.
Oh, crap. I'm kind of blocking the view, but Blandino is in his jailhouse jumpers with paperwork right behind me right here. He'll be making his appearance in a second.
Okay, State of Nevada versus Kim Blandino, C341767.
Right there. There he is.
Judge, I'm my own counsel. I'm appearing pro se for Kim Blandino. I've got ankle cuffs on, and I need to go to the table so I can access my paperwork. Is it reasonable to take off these handcuffs so I can come to the table? And I've got standby counsel next to me. Lamont Walker could pick me up and crush me with one hand. If anything happened, I guarantee it, nothing's going to happen.
Good morning, Your Honor. Mike Dickerson on behalf of the state, bar number 13476.
Good morning. The doctors,
yes, he's chained.
Were unable to make a determination.
Excuse me, Judge, I'd like to rule
as to
on my
competency because defendant refused to participate. Defendant will more than likely be sent to Lake Stein for further treatment and respiration. Pursuant to 178.415, thus pursuant to 178.415, I am remanding defendant to the custody of the sheriff for transport for further observation.
Do I need not, I don't get to make any kind of record here, Judge? This is outrageous. I got a right to make a record.
You can go ahead and sit down, sir.
Hey. Basically, he's been remanded and is being transferred over to, I believe, the wherever he's going to be evaluated. I think it was like Lakewood, Lakeland, or Lakewood, as the name of the place where he's going to have his evaluation for competency.
This is
Lakes Crossing. Thank you very much, Kim.
Yeah, I'll tell you later. I'm sorry.
Yes, we are now in 2020, Kit. Nimrod, thank you for the 20 secs. My cat is snoring loudly and dreaming on my lap. Aw. Aw, get you.
This court farm says at 9:30,
Stephen Hatter versus Alex Yanko, case number C32987.
Good morning, Your Honor. Damon Sheets on behalf of Mr. Yanko, who's present.
And Mr. Yanko is present in custody. 7.
Hey.
All right, so.
All right, we are now at the final video for this evening. April 3rd, 2020.
Mr. Blandino, I normally wouldn't hear your case, but I want to make sure that you get out of custody today. So,
I'm sorry, you want to make sure what?
that you are released from custody today because you were only remanded for the purpose of going to Lakes.
That's
right?
true.
So,
But I have not been able to confer with my standby counsel. How am I going to do that before this hearing?
well, I
And
mean,
Judge,
sir,
I
they-
am
I'm sorry. so
Ben
they-
Bateman here, Your Honor. I am here as standby counsel.
Thank you. Well, thank you. I appreciate that, out Nevada judges, for that point, which is something. Yes, it's also known as a rule of necessity, but I've always known it as a judicial maxim that if everybody is recused, then no one is.
Counsel, I am
Sir,
appearing by.
they found you competent, so my plan was to have you released today and give you a date in Department 12.
Am I going to be able to make a record, though? I wasn't able to make a record last time with Judge Hardy, and I need to make a record.
A record of what, sir? There's nothing else. I'm finding you competent and returning you
No,
to the
I know. I
So the judge just ruled that he's competent to stand trial, and therefore he's being released from custody. But he's arguing that.
object. I want a continuance. I want to have a full-blown competency hearing. I want to subpoena witnesses and all that kind of thing.
Sir, the only thing that happens at a competency hearing is that we would find you incompetent or competent, and they found you competent. So,
Well, I have the right under law to have my own evaluator, because the thing is, there could be
sir, are you saying that you're not competent?
No, I'm not saying that.
Okay, so.
But I still have the right, and I do not have to waive rights.
Pursuant to NRS 178.420.
Remember what I said earlier this evening, that Kim Blandino also wouldn't take yes for an answer? Here we are.
I find you competent to proceed with adjudication based on the reports of Drs. Henson and Dr. Dillinger. This will return to District Court Department 12.
And I object.
Sir, were you on electronic monitoring?
I object.
Mr. Blandino, were you on electronic monitoring?
Yes, but I had July.
What level of electronic monitoring?
My house arrest officer said that I should be at lower medium. I served from 7/14 to January 3rd with no incidents or anything. That's almost 6 months with no incidents or anything. And so there's no way, and besides, it puts people at risk with this COVID virus. If he's got to come into the house, got a 94-year-old World War II vet
This is some of the things I need to make a record of.
Mr. O'Brien, you have any objection to mid? I'm not
looking, Your Honor.
really concerned about
But I have, you know that I want to come to court every single time. There's no way that I am not going to show, and there is no danger to the community issue, so therefore there should be no electronic monitoring whatsoever. Nonetheless, a punitive house arrest, which is what I was on before. I've already been punished, Judge.
All right, I'm going to release Mr. Blandino.
Yeah, but
Yep.
I show house arrest, I don't show what level he was on.
I'm guessing it was high based on the circumstances, but I'm going to release him on mid. I don't anticipate that there'll be a problem.
Can now it's 4 days in the past, 4 to 6 days before I get out on house arrest. Can I be ordered to be released immediately, Judge? I'll report to house arrest.
Wait, but you wanted to object to the finding of competency. And if you had succeeded on that, you would have still be held in prison. You objected to the finding of competency and you wanted a full hearing. But if the judge would have granted that, you would have been held in custody until then, until that full hearing. But now that you've been granted, you've been held competent and are set to release, now you're salty that you're not getting released fast enough. How does any of that make sense, Mr. Blandino?
Return date is May 5th at 8:30 a.m. in Department 12.
Can I be ordered released immediately? By all means necessary. It's going to be 4 or 6 days.
All right. Who do we have now? Do we have Jackson?
Do you have Mr. Jackson in there?
Kendall Jackson?
Can I?
All right, we're done. We're done. That's it. We got to stop there. Or else this live stream is going to take too damn long. And I got to stop. Clearly, we're going to have part 4, which is going to highlight almost all of our Nevada judges' videos, because they pretty much have all of the hearings involving Mr. Blandino from his release from Lakes Crossing until the December 4th and December 6th hearings involving his current criminal case. So shout out to our Nevada judges for the videos and for the content. It's been fantastic. I love it. I've been subscribed to them over the last week and have been following a lot of different cases that they've been following in Nevada as well. So I seriously encourage you guys to check them out, because they provide a lot of really good and useful information in the midst of the hearings. Whenever a judge is mentioned, a prosecutor's mentioned, points of fact about laws, including motions, like legal terminology, like motions, discovery, recusal, and so forth. A lot of different stuff, and I find it very, very informative for the layperson, for those who want to know more about their justice system. So take care of that and take a look at that yourselves. Thank you, Tony Kent, for joining as a member. Much appreciated. So I want to give you guys a shout out. Thank you guys for joining me. I've been having fun with this series. I hope to have part 4 done before I leave for my Christmas vacation. So we'll probably have to do that then. And hopefully I can get Mike to join me in part 4. And I think it'll be pretty good and pretty fun to watch. So thank you guys again. Have a good night. Take care of yourselves. And I'll see you next time. Hit that like button on your way out. It really helps the channel, by the way. Thank you so much.